morning, everyone. Welcome to our second day of our spring oral argument session here in sunny Philadelphia. As you may know, the Pennsylvania Supreme Court is the oldest court in North America. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. Last year, we celebrated the court's historic 300th anniversary here in Philadelphia. We are privileged to sit in three historic courtrooms: Harrisburg, Pittsburgh, and Philadelphia. Here in City Hall, I just wanted to point out a couple of the beautiful historic details in this courtroom. The facade of the bench is constructed of Mexican onyx, with each of the 7 panels divided by bronze statuary representing Greek figures of law, justice, and jurisprudence. To the right of the bench is an Italian marble bust of John Bannister Gibson, who was Chief Justice of Pennsylvania from 1827 to 1851. The cane stone, which houses the bust, bears the Latin inscription, and Justice Weck speaks Latin, so he could correct me if I'm wrong. The Latin inscription meaning, "Bright and full of majesty made the decision." I love that. To the left of the bench is a bronze bust of George Sharswood, Chief Justice of Pennsylvania from 1879 to 1882. Chief Justice Sharswood was a well-respected member of the Philadelphia Bar before he ascended to the bench. Directly behind us is a mural completed in 2002 by 2 local artists, Michael Webb and Max Mason. The view is of Independence Hall's southern facade, with the historic Pennsylvania Supreme Court courtroom to the left. The interior of both our courtroom and the Justices' Conference Room, which is behind us, were designed by George Herzog, an American interior designer and decorative painter. While you're here in the courtroom, hopefully you'll get an opportunity, not while you're arguing, to take a look at all the beautiful accents in this courtroom. Before we hear the first case, I would like to introduce some students who are here with us today. We're always happy when we have high school, college, or law students come to the courtroom to hear our cases. Today, we have juniors and seniors from my alma mater, Lincoln High School in Elwood City. Could you students stand up? Welcome to Philadelphia. Welcome to the Pennsylvania Supreme Court. These students are part of the AP U.S. Government and Politics class, and they are here with their teachers, Mr. David Gabus and Ms. Marcia Kasanovich. Welcome, kids. Also, you can sit down, as part of our 300th anniversary celebration I mentioned earlier, we held an essay contest that was open to high school students throughout the entire state. And the winner of that essay contest is here with us today, Grady Smith. Would you stand, Grady? Congratulations, Grady. Now, let's get down to it. Appellants counsel, when you approach the podium when your case is called, if you'd pause just a moment, I'll give a short summary of the case, and then you can begin by stating your name and the party you represent and by introducing your co-counsel to the court. The justices are familiar with all of your cases, so I ask that you avoid any unnecessary recitation of the facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is, of course, welcome to rely on the briefs for any issues that they choose. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they ask you questions. A justice's question is not meant to trip you up. Rather, it's an indication that there are particular issues we want to explore further. While there's no set time limit for arguments in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I ask that you conclude your argument. Mr. Minner, please call the first case.
Michael and Melissa Sullivan versus Werner Company and Lowe's Companies. Representing Werner and Lowe's, Mr. James Beck. Representing Sullivan's, Mr. Howard Ashton.
In this case, the plaintiff, who was injured while using a rolling scaffold, brought a products liability action against the scaffold's manufacturer and seller. We address whether a jury may consider a product's compliance with pertinent industry and governmental standards under the product liability principles established in our 2014 decision in Tincture versus Omega Flex, Inc. Good morning.
Madam Chief Justice, Your Honors. May it please the Court, I'm Jim Beck, and along with my co-counsel, Ted Hages, we represent the appellant Werner Company in this appeal. Your Honors, we have three main points. First, there should be no bright-line rule here, either for or against admissibility of compliance evidence. Tincture overruled the absolute separation between negligent conduct and strict liability product condition, and instead adopted an incremental pro-jury approach, and thus the per se exclusionary rule imposed by the Lewis case and reinstated by the Superior Court here cannot stand. Second, Tincture restored to juries the determination of whether product defects create unreasonably dangerous products. That's the normative principle now, and here the plaintiffs chose to prove defect by using the risk-utility prong of Tincture's composite test involving alternative designs. Lewis itself recognized the relevance of compliance evidence to these issues. So did this jury. But the question about OSHA not only went unanswered, but the product was altered to prevent this jury from learning of the product's OSHA compliance. Third, the result I'm seeking here is not just the majority rule nationwide, but every 402A state in the country where juries decide these questions has recognized that standard compliance evidence, properly introduced, is ordinarily relevant to whether product designs are unreasonably dangerous and therefore defective. Standards compliance evidence is admitted almost everywhere, almost every day, without any of the speculative adverse effects mentioned in the opposing briefs.
Counsel, if we were to accept your argument, would you agree, would you concede that it would not always be admissible in every case?
Yes, it would be a case-by-case basis. I'm not asking.
And how would you discern that case by case?
It would be on the basis of the relevance of the particular type of compliance evidence. There are pretty much three different types of compliance evidence. There's the prevalence in the industry itself of the design. That was one of the things raised here. There are mandatory governmental standards, and there are these consensus industry standards mostly created by standard-setting organizations such as ANSI in this case. Each one of those has somewhat different attributes to it that would have to be considered in an individual case, but I think they all meet the basic relevance standard of whether it makes any fact more or less probable under Rule 401 of the evidence.
Well, if we would hold that, you know, you're right, but we're going to do it case by case, it seems to me that it might be creating a quagmire for the trial courts to sift through.
I don't think so. Your Honor, we admit the same kind of evidence under the same kind of standards in negligence cases and have for over 100 years. And it's never created a quagmire there. I don't see that that's, and it's done in 40-something states otherwise, and we've never seen cases that create, that there's a quagmire because of this aspect of the evidence. It can be admitted. There are situations under which it might be excluded. If you want an example of one where it might be excluded, it would be a situation where, say, the standard that the defendant says they complied with was not actually in effect at the time the product was manufactured. That's a case-by-case basis on which it might be excluded.
I'm sorry, just one more question. As a broader prospect, couldn't it be misleading to a jury when these types of standards are admitted? I'm thinking back to the Ford Pinto case.
Could be. This is a case, I think, I'm looking for a case-by-case basis. This is evidence. We're not trying to set a rule here, at least I'm not. It could conceivably be misleading. If there is evidence of that, which there is none in this case, if there's evidence of that, then you would have your usual 105 Rule 105 pretrial hearing on that, and the court would decide as the gatekeeper of the evidence whether or not in that particular case, in a Ford Pinto case, I'm not sure they're any more around anymore.
I hope not.
In that kind of, I hope not either, but in that kind of case, it would be on a case-by-case basis, just like we do it in every other kind of evidence.
Counsel, can I follow up on that, Justice
Yes.
Donahue? And I'm glad you mentioned that, that we're talking about evidence. What I don't see anywhere in this record is an offer of proof.
It was,
Let me just go through with this, and I'm sort of looking at this from the perspective of somebody who used to try cases. There's some assumption here that everybody knows what you're talking about. For example, what are standards in the industry, and how are they formed? And what are they exactly relevant to in this case, where the 7 factors were used in order to establish a defect? And how are we going to get this into evidence? I mean, I'm really groping. What I don't want to have happen here is that we are writing an opinion at 30,000 feet, because what we were waiting for after tincture was a case where the issues were clearly articulated and presented. And so maybe you could help me out with 2 things. Why wasn't there an offer of proof? How was this evidence going to get in? And what was the purpose of it in this case?
okay. There was no offer of proof because this was done by in limine motion. It was done by a pretrial motion, and it was granted, and at that point, it was out of the case, and there was no ability to go and make an offer of proof at that time because it had already been excluded, and that's enough to preserve the issue for
It's
purposes.
not a question of issue preservation. I get it. The issue was preserved, but you said it again. Then we couldn't get it in.
Okay.
What was it?
What was it? It was 3 things. There was the prevalence of this particular product design among the industry. After the plaintiff brought in examples of other designs that were available, we sought to counter that with evidence of several, 6 or 8 scaffolds, different scaffold designs that had the same design, and prove that this was in fact the most prevalent design, and that goes to several of the factors, the Wade factors, such as the expectation that the user would be aware of the product's condition and the product's attributes, and the more frequent the user has to see those attributes because it's a prevalent design, then that goes and makes that more likely that the user would be familiar with the product, familiar with its risks, and able to avoid them. That's one basis for that type of evidence. There was also OSHA and ANSI standards. Those were the ones that were flatly rejected.
Let me just follow up. So it was being offered to establish that the design was prevalent in the marketplace.
Yes, it was. Well, it was for the reasons being that is relevant to the Wade factors that the jury was instructed on. It's not that it's relevant to somebody's due care. The jury was not instructed on due care. It was instructed against due care.
I understand that, counsel, but the Wade factors were specifically instructed at the request, and I don't think there are any objections to the use of the Wade factors in this case.
There is not.
Which of the Wade factors do we're talking about industry standards, correct? Which of the Wade factors do the industry standards shed light on?
Okay, industry standards and governmental standards are relevant to the Wade factors, such as first, the user's anticipated awareness of the risk. That's mostly the prevalence of the design. There is the Wade factor for the availability of feasible alternative designs.
How does it go to that? And I'm sorry to press you on this, but not having anything in the record from which to draw these kinds of conclusions, I need you to fill me in on this.
Okay, well, if the government sets a standard, then
This isn't a government standard we're talking about.
well, the OSHA aspect of it is a government standard.
Okay, so
There are
you
th-
wanted
there-
to offer
that's what I said, there are three
both
different-
OSHA and industry
ANSI, the
standards.
American National Standards Institute, ANSI, which is a private standard-setting group that does this for hundreds of products.
Pardon
They
me,
recommend, those standards,
Counsel, before you go on, you're talking about OSHA standards also?
yes.
Okay.
OSHA and ANSI were both in the expert report. That's in the record. That is what we would have discussed had there not been an in limine ruling on that subject. There's one of the weight factors is the availability of alternative designs, and if you have, the government can set what the design is. A governmental standard can preclude an alternative by saying you're going to do X and not Y. An ANSI standard can say we have looked at these and we think this is the optimal way to do it, or it could be there's a range of things within certain performance standards that would be available, and the defendant can argue this is one of them. That's how that would be relevant to alternative designs. There's also the question of the safety.
Can I just follow up on that? That I don't quite understand. The plaintiff in this case offered an alternative design through an expert witness, correct?
Yes.
Okay. I don't understand how ANSI or OSHA helps in defending against an alternative design. Unless the
OSHA,
alternative design...
ANSI, okay.
Go ahead.
ANSI, in this particular case, approved the design criteria that this product met. And that goes to making it more likely that our design is a safe alternative and is just as safe or safer than, and has less of the other factors.
You're going to have to say that again, sir. I didn't follow that.
Okay.
I'm sorry.
The alternative design that our product represents was approved by, met with the ANSI standards.
The industry.
The industry standards, and it was also satisfied the OSHA standards, and the balancing that was done, the trade-offs that were done that represent that standard show that this was not an unreasonably dangerous design to use. There are other alternatives, but this alternative meets with the kinds of trade-offs between efficacy and between safety and cost, so that our design is at least more likely to be not an unreasonably dangerous alternative to the design that was introduced by the plaintiff.
Therein lies my question and/or problem. And let me just make it clear. I mean, I'm open to the notion that there is a place for this evidence in design defect cases. I just don't see anything here that convinces me of that. I mean, what you just said essentially is that what you were attempting to offer through, I don't know if it was ANSI or OSHA.
It was through an expert witness that would have discussed how these standards applied into the design process that produced this product.
We don't have that, but before us, there was no offer of proof. But let me just finish my thought. What you just said is you essentially wanted to offer this to show that ANSI and OSHA establishes the risk utility conclusion that is the ultimate question in this design defect case. And that I have a problem with.
Not establish. It is evidence. It is not, ANSI and OSHA are not binding. They have a range of designs in them that show that they think these are reasonably safe designs. They are not binding on anyone. The jury can disregard them. The plaintiffs can urge the jury to disregard them. But they meet the bar of relevant evidence in that they have some tendency to make an established fact, such as the safety of this design, more or less probable in this particular case, or in any particular case, because what we're talking about here is a per se rule that was adopted that these don't come in any case.
I get it, but you see, you know more about this than I do, counsel, and I respect that. You've been doing this for a long time. But when ANSI standards are, when these standards are adopted, is there a risk utility test that is taken into account before the standard is adopted?
The ANSI committees have people on them from both sides. They have industry and other representatives on them. They try to reach a consensus.
On
They
what?
call them
On
consensus
what?
stands.
On what?
On that this is sufficiently safe that it can be sold in the marketplace. That's what they do.
So there's no risk utility analysis.
There is a risk utility balance inherent in how ANSI's committees go about forming these standards. And the standards themselves are not hearsay. They're basically considered to be substantive facts.
Okay, let me ask you that question. Why isn't this hearsay? If you are offering for the truth of the matter asserted that these standards establish, and I'm not sure what, either the safety or the risk utility, why isn't that hearsay? And I looked through all the hearsay exceptions, and I'm sure you're much better at this than I am, but I just don't see why this isn't hearsay that's not going to be subject to cross-examination.
It's never been. This is admissible in 40-something states. They've never considered it hearsay.
Consider me dense. Okay.
Okay.
I mean, I'm just asking you, why isn't it hearsay?
of an ANSI standard, the fact of a governmental standard is subject to judicial notice. The fact of an industry standard is considered in the states that allow this to be a fact that is determined the same way you prove facts. This is the standard. You bring in someone with personal knowledge of the standard, they discuss what it is, and then decides debate on whether this complied, if that's what it's being used for.
Can I jump in?
Yes, Justice Wecht.
With respect to the Standards Council, how should we consider articulating a rule that courts should follow regarding the admissibility of that standard evidence in circumstances where in a given industry you may have just a small number of dominant suppliers, and since you've began by arguing against a per se rule, how should we consider outlier circumstances like that where dominant suppliers may have set standards so low that if the evidence goes to the jury, this is the standard, that inherently conveys an authority to the jurors, this is good enough. And how is the jury ever going to be able to reach a conclusion that, you know what, in this particular industry, the standards have been set too low? Is that something that could even ever happen under your view of this area of law?
It could happen if there's evidence put in the record of that the standard was, one of the examples given was written by a lobbyist. Then you bring evidence and you have a Rule 105 hearing on it. As far as what you would say to a jury or tell courts to do, this is done all the time in negligence cases. I would just say you apply the same procedural standards to strict liability for that than you would apply in the negligence cases that we have done for 100 years.
Well, of course, this isn't negligence. I mean, you do acknowledge there's still a difference between strict product liability.
Absolutely. There's an overlap, but the section A2 that my friendly opponent, emphasizes, that is where the overlap ends. Due care is where the overlap ends. A defendant cannot introduce these as evidence of its due care. If it does that, even under my rule, that would be likely to raise a Rule 403 question because it would make that evidence confusing to the jury.
That was my only other question for now. 403 was, because I appreciated you began by saying you're arguing against a per se rule. And I'm wondering how, in your advocacy here, you're not by implication saying that with this species of evidence, the probative value is always going to exceed the prejudicial effect and get over that bar that you were talking about.
Your circumstances might be one situation where if there's actual proof of that, which there's none in this record. That's not something that was ever argued by the plaintiff, that there's anything wrong with the ANSI standard here. But if there's a case like you talked about, where there is evidence of industry overreach or something of that nature, then that would be something you have a Rule 405, a Rule 105 hearing, and you raise a 403 question that because of that overreach, demonstrated by whatever evidence there is, then in this particular instance, it's either could be confusing to the jury, a waste of time, or whatever the 403 issues is.
Mr. Beck, let me just ask this quick question. Could you clarify a statement you made a little bit ago that the industry standards have input, in the establishment of industry standards have input from both sides? Who are the both sides?
Okay, these standard-setting organizations are made up of engineers, and anyone who is interested in it can apply to be on these committees. And one of our amicus briefs discusses this at length. Both sides' experts participate in these consensus attempts to reach consensus standards. So it's not like it's only industry that is involved in. It's not always the other guys do it too, because the people who support the plaintiff side are also in the room.
Okay.
And they try to reach a consensus, and they do this. There are tens of thousands of these standards out there from the various groups. This per se rule would throw them all out, and that's why we're here. I assume that's why you took the case, because of the great possible breadth of this per se rule that the Superior Court recognized.
Justice Dougherty?
Based upon your explanation of your understanding of industry standards, I'm beginning to understand, it seems like you're advocating for us to write that industry standard is an element of the duty of care, which falls within negligence. Considering this is a strict liability matter, or share with me why this court should not write, based upon your definition of industry standards, that it's really relevant to the element of duty of care, which is not applicable to strict liability.
If it were framed as a negligence issue, it could be relevant to due care, but it's not, and it is only relevant to the issues that are before the jury in a strict liability case. Here, that are the 7 Wade factors. The Wade factors, where you have, what's the cost and benefit of this, and this is some evidence that a jury could find that there's a sufficient cost-benefit ratio because this standard applies that. You're not going to be able, as a defendant, to just go and plop on the desk and say, here's the standard, we complied with it, we should win. It has to be tied in to one or more of the Wade factors if it's a risk utility test, or to the consumer expectations test, which is not used here, but should that be the relevant prong that is before any particular case. So it's not that you just put it on this. You have to go and set a foundation for it and establish through expert testimony or otherwise that this affected the design process and the trade-offs that created the safety profile of this product, which is what the condition of the product is in this case on strict liability. If it goes to due care, if the defendant argues due care, they're going to have that evidence is going to be excluded in strict liability because that's where due care is where the overlap ends.
Counsel, can we get back to the Wade factors? I'm looking at Wade factor number 2. The safety aspects of the product, the likelihood that it will cause injury, and the probable seriousness of the injury.
Yes.
Okay.
And
back to the issue that I have with this record. I assume that you would argue that the standards, both OSHA and ANSI, go to that second Wade factor.
It would,
Is that correct?
and if we did not have an in limine ruling, we would have had an expert testimony about that, and then the jury decides which side they believe. But yes, an expert can put on evidence that piece A, B, and C of this ANSI standard, which I think in this case is 1018, would be relevant to the safety aspects of this product, and hopefully you'd be able to say it's relevant to the safety aspects that were causal in the case.
I'm looking at the rest of the Wade factors, and I just don't see, as I understand what the ANSI and OSHA that you're talking about are supposed to encompass, I don't see where else they fit into the equation. And so I don't know, I mean, is it your argument that they should be, that the standards should be admissible to establish the safety of the product?
Yes, the safety of the product, the trade-offs between it, the cost of alternatives.
That's a different issue. See, that's why you keep going down this rabbit hole with this. I mean, I don't know that that's what the ANSI or OSHA standards do. And if there's actually a cost-benefit analysis that's done in the formulation of the standards, I mean, that goes to the ultimate question that the jury is asked to decide. And I get back to my question. How does anybody cross-examine the legitimacy of that cost-benefit analysis that you're arguing are established through the ANSI and OSHA standards?
It's not conclusive. It is one piece of evidence that the jury can weigh in any given case, that if they can choose to disbelieve it, the plaintiffs can urge them to disbelieve it. But you're saying that
Go ahead, I'm sorry.
the result of the per se rule here is that there is no ultimate authority except the litigation-specific opinions of paid experts. And what you do is you put the OSHA standard or the ANSI standard as one element that they can consider and discuss with the jury and discuss in their opinions.
And the expert would what? Testify as to how the standard is formulated?
Not necessarily how they're formulated, unless it is challenged that they're formulated for some of the reasons that Justice Weck talked about. It's, do they meet the standards? You don't need to go into the background of them in any case, only if it is challenged for some reason.
But there's the rub. That's the concern I have about this. Hopefully we will never have a Ford Pinto scenario again. But if we did, reviewing that evidence, that car met the industry standard, and yet it killed a lot of people.
And Ford was found liable in many cases where it notwithstanding meeting the standard, because the plaintiffs successfully argued that the standard was no good and the juries rejected it. So that's all we're asking, is that that both sides be allowed to go and bring the standards and then present it to the jury and let the jury decide.
Yeah, I guess that's when I asked, could it be misleading to the jury, that's the concern I had in mind.
Yeah, well, in a particular case, that's an extreme case. There are hundreds of thousands of these standards, and you're using an extreme case to justify a per se rule that would throw them all out.
I was just asking a question.
Okay, but anyway, that is the Superior Court then was using extreme cases. My good friend here was using extreme cases to justify a per se rule that throws out everything from ANSI standards to the FDA.
Counsel,
Any kind of case with a strict.
can I just?
It's not a per se rule. I mean, it's not a per se rule. I mean, if the plaintiff opens the door, then you get in your standards.
Yes.
And sometimes that happens. I mean, that's not unusual for that to occur.
That does happen, but Your Honor, what I would like to have is see that one-way door become a two-way street in these cases, and the defendant has the same right to put that before the jury in the first instance as the plaintiff does. And then the jury decides.
Where you're going ultimately is, if the plaintiffs have the ability and authority to introduce an alternative design that is safer, which they do, then you should have this
We should be able to contest
opportunity.
it. We should be able to contest it.
And that's a fair argument.
And this is a matter of what the briefing calls dual relevance under Rule 105A, and that this is evidence that could potentially, if it were phrased in a different way or phrased incorrectly, go to the issue of due care. It is also the type of standards that can go to issues such as the safety aspects of the product that are relevant to 402A. And we've done that several times.
Counsel,
I think
can
we understand. Do you have other questions?
I was listening very attentively to what you were saying, and I just want to make sure I understand it, because I think you contradicted yourself and you didn't intend to do it. You're not asking us to rule that this evidence gets to a jury. You're just asking us to rule that there shouldn't be a per se bar to the court considering it which is what the court did here. They just applied a per se bar. They didn't do a standard admissibility relevancy equation, because just a few seconds ago you said you want this evidence before a jury. You're not asking us to rule that there's a per se rule that it goes to a jury.
In a general sense. is what
Okay.
In any particular case, there may be reasons why under Rule 403, usually, that there's a reason it wouldn't come in that case.
Right.
But that there is
You don't want a
per
per
se
se
rule, it can be presented.
You don't want a
have
per se rule either way.
We don't have a situation where you get an in limine ruling and that's, you can't even reconsider it, and that's the end of it. And we don't, that's one of the reasons we don't have a full record here.
All right, any other questions? Thank you very much, Mr. Beck. We'll hear from Mr. Bashman. Let me guess, you don't agree with that.
You are correct, Your Honor. Chief Justice Todd, and may it please the court, my name is Howard Bashman, and I represent the plaintiffs Michael and Melissa Sullivan. With me at counsel table are Jeffrey Laffey and Stuart Ryan. Let me begin just by discussing some of the facts of this case, which were not discussed at all in the other side's presentation, because I think it will help this court understand how this issue arises. This case involves a type of rolling steel scaffolding that is constructed according to the instructions, and at that point, there's no dispute that the scaffolding is safe. However, when the scaffolding is moved from point to point, as it was here 3 times, the condition of the product can change, and the platform can become unseated and not be noticed by the person using the platform, and that's what happened here. So the top of the platform became unseated. My client went up to do additional work on the platform, and he fell through the platform. And so this is a situation where the defect is as a result of using the product as opposed to the product in its original condition once it's constructed. Now, I believe that the industry and governmental standards that my esteemed adversary is discussing focus on the condition of the product when it's originally constructed and not necessarily when it's used. And in fact, the plaintiffs put in evidence of these other scaffoldings that don't manifest this defect when they're moved around. And the jury in this case was laser focused on the precise product that was being challenged. And as you've heard this morning, what the defense would like to do is to bring in examples of similar scaffoldings to its own and industry and governmental standards that it says show that it at least meets some minimum safety level. But that puts the plaintiff in a case like this at a severe disadvantage, because the jurors are going to think that the folks who came up with these industry and governmental standards are experts as compared to themselves, and that the industry and governmental standards considered the evidence, usage, and the condition of the product that's at issue in the case, which, as Justice Donoghue, I believe, correctly observed, there's no evidence whatsoever to establish that, and there's no way to cross-examine the creators of these standards to determine what level of thoughtfulness went into it. We discussed Ford Pinto, but and you know, I agree there never should be another case like that, but the Takata airbags, you know, come pretty close to that. And so Ford Pinto is not a single example. Takata airbags were marketed and they complied with governmental industry standards. Justice Donoghue, you touched upon the rules of evidence and the exception to the hearsay rule. One of the reasons that Pennsylvania is different from other states is that it has not adopted the learned treatise exception to the hearsay rule. And I believe that can and should prove fatal to the ANSI standards. Maybe governmental standards would not be that type of evidence.
How do you reconcile that, though, with the fact that they're admitted regularly in negligence cases?
I think that what the other side wants to do here is to put the actual standards in front of the jury, as opposed to just saying that, you know, I the expert, looked at the standards and they were satisfied here. So I think that may be the difference. But I don't know that you can actually get the industry standards in front of the jury by reading them to the jury or by just putting a copy of them before the jury. I think that, again, it comes through expert testimony that the expert has looked at it, and that's his opinion that it complied with the standards.
Well, Mr. Bashman, we don't really know. Because it never got past a per se bar motion in limine. You never had a chance to argue, are these standards hearsay? There was no, we never got past that. They just want to get past the per se bar. So all these things that we're talking about, how do they come in? Is it hearsay? Are they going to read the standards and relevancy, all that stuff? You never got to that discussion in the trial court because the trial court just applied the Superior Court precedent and said per se bar, it's over.
I don't disagree with that. In other words, I do agree with what you just said. That was not considered in this case.
So what's wrong with getting rid of the per se bar, letting the trial court judges decide it on a case-by-case basis, and if they let it in, let the very skilled lawyers on both sides of counsel table destroy the expert or prop up the expert, and the jury gets charged, and that's it?
Well, there are two things that are wrong with it. The first is what I touched upon earlier, which is that it creates a sideshow or a case within a case, focusing on these things that are simply that the manufacturer exercised due care. And then secondly, it's that this court, of course, would have to overrule the Lewis decision, which I didn't hear the other side spend any time at all even acknowledging exists, which had two bases for its rule that industry standards, that was a similar case involving the fact that there were other types of equipment that had the same type of operating system that made it easy to press accidentally. And so the two grounds in Lewis that this court relied upon were, yes, one of them was based on Azzarello, that you have to keep strict liability separate from negligence, but the other was that it would improperly divert the attention of the jury from the product to the reasonableness of the manufacturer's conduct in choosing its design. That to me, and the three-judge panel in this case found that second basis for this court's ruling in Lewis remains good law, even in the aftermath of Azzarello's overruling. And
Tincher didn't overrule Lewis.
I'm sorry?
Tincher did not overrule Lewis.
Correct. Tincher did not overrule Lewis. Even Justice Saylor, in his Bugash dissent from this court's dismissal of the acceptance of review as improperly granted, said that it would be possible that if this court adopted the third restatement, that Lewis could remain good law. And unlike in Tincher, where numerous justices of this court had spoken out repeatedly to criticize the standard that was before the court in Tincher, I haven't seen any criticism similar to that of the Lewis case. The current system works. If this court were to overrule Lewis, it would require the retrial of numerous cases that are in the pipeline right now that have gone to verdict and that are currently on appeal. It would result in less safety, not more safety.
Counsel, can I follow up on this entire issue? And Justice Brobson raises the issue that, on its face, makes sense. Why not just let the judge decide in each and every case? But I'm sort of hung up on still my predicate question. I understand there was a motion in limine in this case, but there was argument on the motion in limine. And when there was an argument on the motion of limine, there wasn't an offer to establish what was going to be the defense perspective on what the jury should hear. I don't see it as a waiver argument, not by any stretch of the imagination. But what I'm saying is it leaves me at a loss as to understand what the standards were being offered to prove. Right. In other words, what were they relevant to use the terminology that your opposing counsel uses in their brief. Now, I'm looking at the weight factors, and apparently that's the de rigueur to use the weight factors to establish a design defect. Okay, so that's what happened here. Why don't the ANSI and OSHA standards go to the second weight factor, the safety aspects of the product? Now, it goes further. It says the likelihood that it will cause injury and the probable seriousness of the injury. That's what the jury is supposed to consider in deciding whether it's safe in that regard. Do the ANSI standards and OSHA standards go to the likelihood that a design will cause injury and the probable seriousness of the injury, or not?
No, it just goes to the fact that this industry organization has decided that scaffolding of this nature should have certain features. There's nothing in the record to demonstrate.
Well, tell me, you do this kind of work. I mean, what exactly are the ANSI and OSHA standards doing? They're saying it's safe, correct? Yes, no? See, that's the problem with deciding this case in sort of the vacuum that at least I'm living in.
No, I think that on our side, we would not be adverse to the court deciding that this is not a good case to decide this question. But to answer your question directly, the OSHA and ANSI standards are not in the record, and so is the appellate attorney in this case. I can't tell this court what they would or would not establish because they're not there. I'm at the same disadvantage
Well, that's not
as
true.
you
There's an expert report by the defendant's expert that
Right, and
says what that expert was going to say.
Right, that this scaffolding complied with those standards.
Period.
Right, is what he said
Period.
in the expert report. Right.
Okay.
All right, any other questions? Do you want to conclude, Mr. Bashman?
Well, we believe, for the reasons that I've discussed, that this court should retain the Lewis decision because its ruling in tincture does not require the overruling of Lewis, and that the fact that this court recognized in Lewis that allowing in this evidence would improperly divert the attention of the jury from the product to the reasonableness of the manufacturer's conduct in choosing its design is precisely correct. Allowing in this evidence would create the type of sideshow and trial within a trial that would be severely disadvantageous to the plaintiff because it's impossible to cross-examine these industry and governmental standards evidence.
Mr. Bashman, Justice Donahue has a final question.
Broad-based question. Where do you see negligence concepts overlapping with strict liability?
We believe that this court got it exactly right in the Rovereno decision where this court said that in Pennsylvania, strict liability law remains a separate cause of action.
That's my question. I agree with that decision wholeheartedly. My question is, where do they overlap? Clearly, in the 186 pages of the tincture decision, there's numerous reference to the fact that there is an overlap. Where do you see the overlap?
There is reference to that, and what the tincture decision says is that strict liability arose as an amalgamation of negligence and warranty causes of action, and that it resulted in a separate and independent cause of action all of its own.
Would you agree with the proposition that in terms of the foreseeability aspect of negligence law, there is an overlap between that negligence concept and strict liability?
No, I would absolutely disagree because I think that it remains the law in Pennsylvania that a plaintiff doesn't have to prove that the defendant could foresee the defect that has manifested itself in order to recover in strict liability.
But that is the one concept of negligence law that the tincture court specifically addressed. It said maintaining these strict lines between these concepts have resulted in unusual outcomes. And they cited specifically to Justice Cappy's opinion in Phipps versus Cricket Lighter. That was a foreseeability case, purely and simply. Obviously, a manufacturer of a lighter could foresee that a kid would pick up a lighter, but keeping the strict lines between foreseeability and negligence out of strict liability led to the conclusion that there was, the impasse was created between, and so Justice Cappy said, no recovery. The tincture court said, that's an unacceptable outcome. Don't you agree? And isn't foreseeability at least the one concept that at least I could identify that is clearly an overlap between negligence and strict liability?
Well, I'm going to stick to original answer,
Please,
but
yeah.
the reason that I was a little bit taken by surprise by the question was simply that foreseeability was not an issue that this case directly presents. The other side's witness, its corporate designee, testified that it was foreseeable to Werner Company that the platform could become dislodged when the scaffolding is moved around, and that's in the reproduced record at 534 to 540. And
Okay, so you would win that point. Okay, but
Right.
that is an overlap between negligence and strict liability. Really, I'm just taking the opportunity to try to make more sense out of the Tincher decision by asking you that question.
Okay.
All right, thank you very much,
Thank you.
Mr. Basham. Thank you both. Well argued. Call the next case.
In re adoption of M.E.L, minor, deal with M.E.L, father, representing father, Mr. Dean Reynosa, representing CMPA mother, Ms. Alexis Swope, legal counsel for child, Ms. Hangey.
We'll wait till everyone clears out here.
Thank you.
Mother petitioned for the involuntary termination of her ex-husband's parental rights over their child in anticipation of a proposed adoption by mother's long-term partner. Under the Adoption Act, the parent of an adoptee must relinquish their parental rights over the child unless the adopting party is their spouse or the parent has shown cause to excuse the termination requirement. Here, we must determine whether the proposed adoption by mother's partner can constitute cause to excuse the termination requirement under the Adoption Act, as the Superior Court impliedly concluded.
Morning, Madam Chief Justice, members of the court. May it please the court, my name is Dean Reynosa here on behalf of appellant father. And as Justice Todd aptly stated the facts of the case, I'm going to go right to the heart of the case. This case is about the for-cause exception. There's two cases from the Supreme Court, RBF and MRD, I believe the initials are. RBF is factually completely distinguishable from this case. In that case, there were two consolidated appeals involving two same-sex partners one of the partners had
Lift the microphone a little bit. Thank you.
in vitro fertilization, and the second case involved a father who had solely adopted two children. And then they wanted to have their partner adopt. And back when that case was presented to the court, same-sex marriages were not permitted in the Commonwealth. In that case, there was a specific reason they could not meet the elements of the Adoption Act. They could not marry and the adoption could not proceed unless the other parent,
And that was cause. That was found to be good
That was found to be cause. MRD did not reach the cause analysis per se. They essentially, the court, Justice, I think it was Justice Todd who wrote that decision, indicated.
And the concurrence.
And a concurrence, that's right, a special concurrence, I believe it was titled. In that case, the court determined that there was gamemanship going on. It was not it was not a new family unit per se. That new family unit, because the mother was having her father try to adopt a child and tried to terminate the father's rights.
Well, and if I could just mention something that I think is relevant to this case for both sides, in my concurrence, which was not a majority opinion, it was just my offering, I indicated that societal norms have changed and we don't live any longer in a society where every family is expected to have a mother, a father, and children. Sometimes there's a single parent raising children and doing a perfectly good job of it, so that I thought that this cause requirement and the spousal requirement was an anachronism. Nonetheless, in my concurrence, I acknowledged that that's a question for the legislature, and I, in essence, asked the legislature to revisit this, and that was 2016, and they haven't done so. So I have to assume that the legislature is fine with the spousal requirement and is fine with the statute as it is. So given that backdrop, please proceed.
Sure, and I acknowledge that. The society is changing, parents and families are changing as society changes. However, the legislature, I think, is the body in this Commonwealth who makes the law. The legislature provided for an exception to the relinquishment requirement. That exception is in step-parent adoption cases. They have not, the legislature could have, after the invitation from Your Honor, to revisit it and change that law to say, okay, well, now might be time to change that and allow this for-cause exception to also include or allow the requirement to not be there for situations like the one we have here. They didn't do that, and that's how this case is different, I think.
Counsel, let's follow up or flesh that out. 2901 specifically says, unless the court for cause shown. While I agree with Her Honor that it is left for the General Assembly to catch up to the evolution of the new family structure. But this is this statute specifically permits the court on a case-by-case basis to decide whether for cause has been shown. So if the evidence on this record is that mother and paramour are longtime lovers for 5 years or more, share a child, and have an intent to continue this relationship, why is that not sufficient, excluding the old term spouse? Because 10 years ago, when we said spouse, we could not include same-sex spouses. We had to terminate parental rights and do second parent adoptions. So let's step aside the whole General Assembly scheme, because that's not necessarily relevant to the statute, which places the focus on the court for finding just cause.
So what's the cause?
But my question is, why should a court not find that a long-established relationship between a man and a woman who are sharing a child amongst themselves and now wish to bring this other child into the relationship based upon the fact that the child doesn't know who dad is and assumes paramour is dad and calls this person dad, and that this is about the ultimate permanency for a child, why would you argue that that's not overwhelming evidence, clear and convincingly, to show for cause has been met?
To answer that question, in this case, the Superior Court analyzing the for-cause exception of 2901 says for cause as, and it was citing to RBF and MRD, the Superior Court in this case said when parties cannot attain all the elements of an Adoption Act. In this case, I don't think that's the case. I don't think there's a situation where they cannot follow all the requirements of the Adoption Act. They choose not to. I think the testimony at the termination hearing was
What have they failed to accomplish?
to get married.
But why is that?
Can I have counsel argue instead of the court?
Could I follow up on Justice Dougherty's question there?
Wait, he still haven't answered my question, because this is pivotal to me.
They cannot. I think they choose not. The testimony at the termination hearing was mother said that was asked, are you going to marry? Is marriage in the future? If I recall the testimony correctly, she said that might be in the cards in the future, not right now. The answer was we cannot marry, we do not want to marry, and we're not going to marry. That might be in the future. So that's why they choose not to meet the elements of the Adoption Act to qualify for that exception.
I got that. Maybe they didn't marry for, the record wasn't brought forth. Maybe they didn't marry for religious reasons or personal reasons or political reasons or financial reasons. That was not delved into. They are facts to be considered. The question before this court is why should we not take the totality of the evidence as proffered to the court to determine whether clear and convincingly cause has been shown to permit this second person adoption. This is not about whether they're getting married. This is about whether that child's going to have a legitimate connection to a particular father as opposed to a man who vowed not to pay child support and only comes in after the termination petition has come. So share with me, are we to take into consideration that your client refused to pay for this child, has not seen this child, the child doesn't know him, doesn't know his name, and doesn't refer him to dad? Are we to assume that those facts should not come into this record to determine what's the best for this child and this child's future and his permanency?
I think what the court has to do is follow the Adoption Act.
So is the question, should we take that stuff into consideration? Because you seem to be arguing we should be taking into consideration the fact that mother indicated, well, we may get married down the line. See, that's a potential speculation. We have evidence and proof that your client refused to pay support, supported agreed not to pay support, and hadn't seen the child for what, 2-3 years, and the child at a tender age doesn't even know who's David? Oh, it's somebody I go to school with. Is it your contention that those facts are not in this record for our judicial determination whether for cause has been shown?
Your Honor, I believe, respectfully, I believe the fact is that there's an Adoption Act. The legislature has
I've asked you a question. It's a real simple yes or no answer.
the record is what the record is. The facts are there. The court has to consider what the record is. Those are the facts that are the record. But again, I go back to my argument as cause, what the legislature has said, what's required for adoption. Either a spousal, either there's a step-parent adoption, or both parents relinquish their rights, and that didn't happen in this case, and there's no reason as to why that cannot happen. As a Superior Court, as what happened in RBF, it could not happen.
But see, I fail to follow that logic in the sense that the one key missing in the Adoption Act is determination of father's parental rights. Yet 2901 specifically says, unless good cause can be determined otherwise, no decree shall be entered unless the natural parent's rights are been terminated. So you're trying to use the argument that, well, we haven't met the element of failure to terminate dad's rights, when the concept of 2901 is to circumvent that if we could show good cause, AKA, he doesn't be involved in the child's life. The child's of a tender age and wants to develop a relationship and a long-term legitimate relationship and financial security with another. So I'm confused. How do you say what's missing from the Adoption Act in this particular case pursuant to the specific statute 2901?
I go back to how the court has interpreted that 2901, and there's a dearth of case law. There's only two cases essentially from this court, RBF, and in RBF there was a situation where that cannot happen. So they found good cause. So the parent, they cannot marry, so there's good cause. In MRD, that analysis wasn't reached. Justice Baer was concerned in his concurring opinion as to saying, again, that's for the point of the legislature to decide that. This whole concept of a new family unit, creating a new family unit, well, that's not in the statute. That's not in the Adoption Act.
Counsel, could you acknowledge that if father's rights are not involuntarily terminated, he certainly could be denied visitation under the custody laws?
Absolutely. This issue could be dealt with in a custody court. A custody court is not going to provide custody to a father who has not been in the picture since 2019.
And I don't disagree one bit with everything Justice Dougherty has said about what would make sense in this case, what would be right, what we'd like to do. I just may differ in the sense that I do think it's a legislative determination whether to remove the spousal requirement. And so I guess in that
but the child loses out on how many years of child support, because support is retroactive to the date of filing. So now, all these years the father had left the child and didn't support the child goes without financial assistance and could potentially be penniless, and the child gets nothing. So the child suffers for the sins of the father for what? A statute which permits the court the discretion to make a determination of for cause. But that's a discussion further back.
Could I get a question in here?
Yes.
At the beginning of your argument, you acknowledged that we're here on 2901, the cause exception. We're not here on 2903, step-parent adoption. You're with me so far, right?
Yes.
Okay. Why, and you stand on MRD, and as you know, I was very concerned in that case with the gamesmanship. Yes. But the facts in this case are very different, aren't they? I mean, isn't it possible that in taking this case, we were interested in explicating the cause exception? And the fact that the legislature has left that provision in would suggest, would it not, that this court can expound what cause shown is. And to the extent that that's the case, why isn't this an appropriate case for an opportunity to show by clear and convincing evidence that the adoption should go forward? In other words, isn't this the case that, unlike MRD, is the appropriate case for the cause shown exception? Isn't this the case that tees up for us an opportunity for the appellees to establish cause shown, given the apparent absence of the gamesmanship that troubled us in MRD, because otherwise, aren't we just nullifying the legislature's authorization for the opportunity to show cause? Doesn't it just render it a nullity?
I appreciate the question, Justice Weck, but I respectfully disagree. What I see here is I've gone and I've looked at the authority, the opinion, RBF specifically, and in there was a cause, there was a reason they could not marry. And then there's obviously a disagreement amongst this court that's been going on for obviously through MRD and more, and there was an additional case by Judge Doherty that didn't really talk about the cause analysis, but there's obviously a disagreement amongst the court about that. But I go back to what the Superior Court said in this case, that 2901 is there when the parties cannot meet all the elements of the Adoption Act. And again, I don't think we have that here. We don't have a situation where the parties cannot meet, so cause doesn't step in.
Well, we're gonna have a long discussion about this, I'm sure, within our court. I guess one of the questions is how broadly we could read for cause shown, because my proffer is that cause shown means cause why you cannot meet the statutory requirements, not cause shown by other reasons why this would make sense. And there are plenty of other reasons why this would make sense. But cause shown why you cannot meet, why she cannot meet the spousal requirement, in my view, at this point, there are two solutions to that. One, they marry and meet the spousal requirement, or two, they demonstrate why they cannot meet the spousal requirements, such as he's encumbered to another wife in another state and he cannot remarry. Maybe that would be cause. I don't know. But to my view, as I've read it, cause pertains to your inability to meet the statutory requirement. And I imagine that's your understanding as well.
I'll leave it at that, Your Honor. That's how I'll finish my case.
And let's-
But that would
let me
require a
just-
remand, wouldn't it, counsel?
I'm sorry?
But then we would still affirm the Superior Court. We'd it would be remanded, and there'd be an opportunity to establish, for example, I live in Utah, I can't get a divorce, that's where I was married, now I live here for the last 20 years, but I'm still married, so I can't get married again.
But I think...
So that's a perfectly legitimate reason why you can't meet the statutory requirement, but that would require a remand.
But I think the court can at least provide some instructions and guidance as to for cause. For cause is, to get to the for cause, you have to establish some reason why you cannot meet the statutory requirements of the Adoption Act.
Justice Doherty?
Yes, share with me in 2901, it specifically indicates that you have to meet the statutory requirements as opposed to unless you can terminate natural parent or parents' rights.
It does not say that, as Your Honor knows.
Okay,
that.
but
It
you
says
just,
for cause.
you just said for, yeah, right, so.
And what my argument follows from the cases that the court has interpreted 2901, specifically RBF, where in that case there was a reason why they could not meet the elements, and therefore cause was found.
All right, this is what makes our job interesting. We don't always agree, and we will figure this out. Thank you. Let's hear from your opposing counsel.
Thank you.
Good morning, Chief Justice. Good morning, Your Honors. May it please the court. Attorney Alexis Swope on behalf of Appellee, mother of the minor child M.E.L, who has legal counsel present, Kelly McNaney. Should the court have any questions for her, or should she feel like I've missed anything? So, obviously my client requests that this court affirm the Superior Court decision and send this matter back to the trial court for a factual determination. Obviously, that's what 2901 intended. 2903, the spousal exception, was an exception across the board. 2901 gives deference to the court to determine whether or not it's appropriate. The fear of opening the floodgates of third parties, coaches, friends stepping in to adopt a child and push out a biological parent, that's for the court to decide, the trial court. And if it's an abuse of discretion, it's coming back up this way for you to make that decision.
Counsel, did your client argue cause as to why the should be excused from the spousal requirement?
No, and the record reflects, we did not even address that evidence.
So is there a waiver issue here?
What's that?
Is there a waiver issue at all?
No.
Okay, so you want to go back to show cause, and the reason why your client can't meet the marriage requirement is
Right.
what?
I don't know what that is. Honestly, I'm going to admit, I don't think we have a reason why she cannot. Our interpretation is at that time she could not. If we're talking about gamesmanship, I think forcing mother to be married to overcome this requirement when there's the ability for the court to make that determination based upon the facts of evidence is gamesmanship.
Well, but
in this matter.
so I don't want to telegraph which camp I'm in in terms of where things are, but it seems to me that rightly or wrongly, whether I agree with it or not, the General Assembly has put a fairly strong indication in the statute that they want the adoption to be to a spouse, and I guess my concern, and I have a great deal of respect for Justice Doherty and his passion on this issue and his experience here on these things, but I'm a statutory construction nerd, and I guess my concern is if the for-cause provision can be interpreted in such a way as to basically not be tethered to the General Assembly's policy, but be, linked to how terrible the father was whose rights are being terminated, or the mothers whose rights are being terminated. It could be either. And these sort of general reasons why you have a bad parent or a good non-marital relationship. The General Assembly could have said that, and if we open up the door there, aren't we basically allowing the for-cause exception to swallow the General Assembly's very express desire that this only occur in a marital adoption?
I don't think so, because 2903, the spousal exception, was enacted prior to 2901, which provides for the exceptions. And if you look at some of the arguments in RBF, the concurring opinion in MRD, you see where they indicate that the best permanency and stability for a child is an intact marriage, because a marriage is much harder to sever than a cohabitation. But I disagree. It's not. Father argues that this permanency for this child lasts only so long as the relationship of mother and boyfriend.
I think that's an excellent argument because I think
Legislation.
Yeah, I think that's an excellent argument because, and I think that's what the chief was indicating, and I'm not going to sit here and disagree with you, but I could probably walk out on the street and find 15 people that do, and that's why we elect a General Assembly to establish a statewide policy on that type of subject, not one that fits a particular judge or a particular court. And that's where I can agree with you 100%. I'm struck with, if I change this, if we say that for cause can be any reason that this relationship is better for the child, then that just swallows the marriage requirement. That's my problem. I'm not sure you can help me get over it.
I don't think I can either.
Okay.
Counsel, we are critical of the statute, and I think you hear from members of the court that we'd like to see the legislature revisit this, but they haven't. But we also have to acknowledge that they considered the public policy and concluded that there was a benefit to having a married person, a spouse, adopt. And you talked about the permanency or temporary nature of marriages versus companionships, but in this case, if the mother's longtime partner, paramour, is permitted to adopt and that relationship falls apart at some point, and mother, who is the biological mother of this child, decides to remarry, then where's that spouse in the mix? That spouse could never adopt the child because her prior boyfriend gained the adoption authority over the child. It gets complicated. So you have to understand the legislature, while we may not agree with the statute, we think it could be updated, they weren't without concern and logic. They weren't disregarding public policy when they came up with this statute.
Counsel.
Could I have her answer that?
Oh, okay. I thought that was a comment, I'm sorry.
I agree, there was concern. And I just want to point out the 2903 for the spousal exception was enacted in 1981. I was born after 1981.
Don't rub that in.
And the exception clause was put in 1982. So, and we're not asking for a blanket, every long-term committed partner should be able to adopt case by case. These parties, mother and proposed adoptive father, they have another child together. He has a child outside of this relationship just as she does. But we're hoping to put that child back in this one. So to your question, if this relationship ends, mother remarries, where does that step-parent fall in? Same place any other step-parent falls in, because the child has a father now with whom she shares a sibling. It's any other marriage or relationship that ends.
Counsel, you think this should be remanded, I take it?
I do.
Okay, but, you know, and with all deference, I don't know if you tried this case or what the strategy was, but as you pointed out, the statutes that we're talking about have been in play for like 40 years. Everybody knew that there was an issue, had to. I mean, not married, knew what the statute said, knew there was a for-cause requirement, and yet no one stepped up to the plate to, like, make the record to say, we just don't want to get married. Okay?
Or we can't.
Or we can't. Although I have a feeling, based upon what you're saying, it's the former. We just don't want to get married. So what are we doing by remanding this? I mean, you know, if the court actually is of the view, and I don't know if that's the case, that, you know, the fact of the matter is you can't overcome the spousal exception, shouldn't we just decide that? Your clients are in a perfect position to fix this. They can get married.
Or we could follow, as I was going to say, General Assembly intentionally doesn't write absurd statutes, but the reality is there's second parent adoption. So if we follow the General Assembly, what the required gamesmanship would be for mother to have her own parental rights terminated so she and live-in boyfriend can file second parent adoption, and then they could be granted adoptions. Correct?
Correct.
So the reality is, which game do you want to play with the General Assembly? Do we want to have mother voluntarily terminate her parental rights so that she and boyfriend can be the legal parents, which is allowed by the General Assembly? Or do we find for cause shown based upon the same facts but a different statute? And I have to differ with my colleagues. There's nowhere in 2901 that says anything about meeting the requirements. You read the statute in toto, it says if all the other legal elements have been met, but for the termination. So mother chooses not to terminate her own parental rights because she has 2901 there, as opposed to another statute. But that, again, it's a policy issue that the General Assembly has given various avenues for you or mother's counsel to choose. It's up for this court to direct which path is best, because either side with either argument is absurd.
It is, I agree.
Well, can I follow up on that point, counsel? Your position, I take it, would be that that you're doing it the right way. You're seeking to establish for cause shown under 2901 by invoking that exception rather than playing a game, rather than doing the grandparent rigmarole or terminating your own rights. And that brought my dissent in CM, of course, right? That you're bringing head on to us the question of for cause shown, and perhaps one might say, if on this record you can't establish clear and convincing evidence then the for cause shown exception doesn't mean a thing.
Correct.
Except for the Utah bigamy, scenario, which is, kind of absurd, right? I mean, isn't your point that if for cause shown means anything, and we don't think the legislature means nothing when it puts something in the statute, that this is a case where you ought to have the opportunity to meet that high bar? Isn't that the argument?
It is, and thank you for making that for me.
But
Because-
you had
because,
the
you know,
opportunity.
go ahead.
You had the opportunity. You just decided not to do it.
Specifically address the question.
Yeah, I mean, let's be honest about what we have here. I mean, this is a gift to get a remand on this, period.
Great.
And I'm not sure what choice we have, to be honest with you. I mean, because we don't have a record. I can assume that your clients just don't want to get married, but I don't know that from this record. So in order to decide this issue at some point in time, we need a record, which we don't have.
Correct, and that's
So the question, I think Justice Robson raised the question, is there waiver, and is that fair in this circumstance when a child's rights are at stake? To find waiver because counsel decided and the court decided just to ignore the elephant in the room.
I don't think there is waiver. It wasn't specifically addressed. Needs to go back to establish the record.
To give you the opportunity to show cause whether or not you can.
Correct.
Okay, any other questions? No. Thank you, both
Good
counsel.
arguments.
Oh, please.
Mr. Minner?
Ronald and Rosemary Hangey versus Husqvarna Professional Products, representing Husqvarna, Mr. Werner III, representing Hangey, Mr. Howard Aplts.
Plaintiff in this case sued the corporate distributors of a lawnmower for injuries he sustained in a lawnmower accident that occurred in Bucks County. The question for this court is whether under our venue rules, the defendant corporation regularly conducted business in Philadelphia County such that venue was proper there. Specifically, we are asked whether the corporate defendant can be considered to have regularly conducted business in Philadelphia County, where its total annual percentage of national sales of lawn equipment within Philadelphia County amounts to 0.005%.
Yes, Your Honor, 0.005 of 1%.
0.005 of 1%, yeah.
Rick Bodie for Husqvarna and Trumbauer, and my co-counsel Mike Muha, who wrote a lot of the briefs and has been educating me on all of this, Your Honor. So, first of all, in Pennsylvania, as Your Honors know, in a products case, there are only a few places where you can be sued. You can be sued where the accident happened. You can be sued where the product was sold. You can be sued where the company has its principal place of business. Or you can be sued where you regularly conduct business. Now, Trumbauer has its principal place of business in Bucks County, and the product was sold in Bucks County. The accident happened 130 miles, 12 miles from the New York border up in Wayne County at a property that Mr. Hangey owned, where he was mowing near a retention pond and drove into a 15-foot ditch. And of course, they filed, Mr. Mongalusi and Mr. Avergan filed their lawsuit in Philadelphia County, alleging that Husqvarna regularly conducted business in Philadelphia County. And Judge New, as Your Honors know, followed the procedure to a T. He set up, we filed preliminary objections, and he immediately set up a discovery schedule with interrogatories, with depositions, with affidavits. And then we had a hearing in front of Judge New. And Judge New very carefully went through all of the evidence. And the evidence was overwhelming in favor of the fact that Husqvarna did not regularly conduct business in Philadelphia County. They have no employees in Philadelphia County. They have no executives in Philadelphia County. They don't have a principal place of business.
But there is a small percentage of business they conducted there, correct?
And applying the law, as Judge Newt did, Madam Chief Justice, he looked at the Cantor case and Purcell and Monaco, and he said all of those cases looked at the proportion of business that a company does in the county. And here, Husqvarna's proportion business is 0.005 of 1%.
May I query on that number? Why, just maybe there's an obvious reason and I'm unaware of it, why is the calculation based on national sales of business rather than Pennsylvania, since we're talking about venue in a particular county within Pennsylvania?
Sure. Well, you look at each case under the law, under Cantor and Purcell, is reviewed on a case-by-case basis. And in this case, Husqvarna happens to be a international corporation. So you're going to look at Husqvarna's total sales, not just in the Commonwealth of Pennsylvania, but in the other states. And the person who knew that was Judge Newt, because in his opinion, in a footnote, you will find that he says there are 3,141 counties in the United States. I didn't know that. And then he divided Husqvarna's business and said, look, if you look at how much proportional business Husqvarna should do on average, it's about 0.03%. And then he said, look, if you look at what they do in Bucks County, where Trumbauer is located, it's 0.2%. But if you look at Philadelphia County, where there are not a lot of lawns and not a lot of outdoor power equipment sold, it's 0.005%, or 40 times less. And
I'm born and raised in South Philadelphia. It's all cement. I grew up with no grass.
I'm not surprised.
At my Home Depot or Lowe's, we may have one lawnmower, no lawn tractors. However, Home Depot sells tractors.
Not Husqvarna. I'm sorry for interrupting, but not Husqvarna.
But it's hypothetical.
Yeah.
So the question becomes if, despite the fact that they regularly do business in our Lowe's with their equipment, but we don't purchase it because our geographical layout doesn't require it. How does that equate to the percentage? Like, why should I apply a percentage quantity quality rationale, which is judicially created, to a definition of regularly conducting business? Because as far as I see it, those who are producing lawnmowers or lawn tractors are regularly doing business, but the percentage of sales is extremely low because you can't mow cement.
So let me see if I can bake that all out, Justice Doherty. First of all, the test is for whether or not you're regularly conducting business. And of course, that goes way back to the general jurisdiction analysis and all of that. Should Husqvarna be regularly conducting business in all 67 counties in Pennsylvania? The way the law has looked at it under, let's take Singley versus Flyer, the Villanova Law School, where Villanova had 3 graduate-level courses down here at the Philadelphia Naval Yard. And when they looked at that, they said, yeah, they're holding classes there, but that's not the majority of Villanova's business. The majority of Villanova's business occurs out in Montgomery and Delaware County, where the fall down actually occurred in Delaware County. And they said, Villanova is not regularly conducting business in Philadelphia County. Now, you brought up another point that's important, and that point is, should Husqvarna be responsible for the sales, in this case of Lowe's, which my esteemed colleague has suggested, but they never developed a record under it, and our position is under our Rule of Appellate Procedure 5, I think they've waived it.
Counsel, can I follow up on Justice Dougherty's question, a little bit different line? Your client has an authorized dealership in Philadelphia, correct? Okay.
It's an independent dealer, DL Electronics, who sells some of Husqvarna's
Okay,
products.
it's an authorized dealer.
It is,
Got it.
correct.
Okay, see, and, I understand the long history of looking at percentages of sales and things like that, but, I mean, the purpose of that test is to determine whether the acts are so continuous and sufficient to become general or habitual. And to me, the fact that your client has an authorized dealership in Philadelphia establishes general or habitual acts in the venue. I'm just loath to the notion that you have to fall back on percentage of sales when you have other evidence that would establish the continuous and habitual, or the general and habitual acts within the venue. So why is that wrong?
Sure. So it's wrong because of the two words that you mentioned. It is continuous, which means regular, and sufficient. And the reason sufficient is important is because that's how Cantor, Purcell, Zampanaberry, Monaco, they all looked at whether or not it was enough.
In all those cases, counsel, if I can jump in, all those cases involved a defendant that did not have a physical presence in Philadelphia. So they're not exactly on point.
So, but there are cases where, for instance, the Pico case, Pico versus Philadelphia Suburban Water. Philadelphia Suburban Water actually has a water line that runs in the county of Philadelphia every day of the week, all the time. And there are other cases, Schultz versus MMI, where they found quality and they didn't find quantity. And so there are plenty of cases where you look and you say, is the defendant doing business here regularly? And the Villanova case, the reason I brought that up, Justice Probson, is Villanova is in the business of holding classes.
I think the Villanova case is your best example, but that doesn't mean the Villanova case was correct.
Right.
So you can't, the exception can't swallow the rule.
No,
and if I'm interrupting you, I'm sorry.
No, that's, I apologize. I guess I'm kind of following up on Justice Dougherty and on his question as well, like Justice Donahue did, is if we overlook this authorized dealer, and maybe there's not enough facts in the record for us to figure out what kind of dealer it is. I think maybe there's a distinction between making your tractors available to Home Depot and Lowe's to sell versus making your tractors available to an authorized dealer. I don't know if there's a difference between the two. Maybe there need to be more facts developed, but to me, I'm the physical presence aspect of it. You seem to be hanging your hat on the idea that, yes, we can have a physical presence in terms of an authorized dealer. I assume Husqvarna does not have corporate stores.
They don't in Philadelphia County. They do have their own standalone dealerships in certain
Well, a
counties.
dealership is an authorized seller, but do they have
They have standalone Husqvarna dealers.
Husqvarna-owned
Dealership.
corporate stores?
Dealerships.
Oh, okay. Well, I think that's an interesting fact as well. But I guess what I'm trying to say is, let's say Husqvarna has one of those in Philadelphia, just because it wants to have a visible presence in a city where everybody lives where Justice Dougherty grew up and there's only pavement. But they want to have Husqvarna's lights so people can see that when they're driving through as tourists or whatever. And they don't sell a single thing. Your theory would say that Husqvarna can never be sued in Philadelphia, despite the fact that they have a store, they're showing equipment, because we just don't sell to people in Philadelphia. So the physical presence under your theory doesn't matter.
So that's not correct. And I've been practicing law for almost 43 years. And sometimes the lack of evidence is significant evidence. And I started by giving a laundry list. Husqvarna has, as Justice Donahue pointed out, they have independent dealers who sell their product, 1 or 2 in Philadelphia County. But they don't have a storefront like the inapposite analogies that my esteemed colleague put up. I mean, Apple Computer. If Apple Computers is selling iPhones, and an iPhone costs $1,000, and you sell hundreds of iPhones in Philadelphia County, you have other evidence that the trial court can look at. You have a storefront. You have employees. You might have a contract with the city of Philadelphia. You might rent property there. And none of those are present in this case. Now, who knew that? Judge New knew that. And what's the test here? The test that the Superior Court was to have followed was abuse of discretion. And under the abuse of discretion standard, Judge New knew every bit of evidence that I just recited to you, and he knew 0.005%, and he knew that the Cantor case and the Purcell case and the Monaco case and Zampanaberi all looked at continuous and sufficient, because it's not just that it happens regularly, it's is it enough?
Could I jump in on that,
Certainly.
Counsel? I take it, and tell me if I'm incorrect here, that you're not advocating today for a bright line test.
Correct. I'm not. Never have.
And what we could say the new argument. Essentially, I guess what I'm wondering is, aren't all of these cases then going to be, abuse of discretion, one of your arguments here, and I'm searching for what possible value we could deliver in a case like this as far as the law goes, when it's basically all going to be the discretion of the trial court. I mean, unless there's a wild outlier in one direction or another, how can it ever be an abuse of discretion if we get a reasoned application of the continuous and sufficient standard, given that there's no, particular numerator denominator, no particular fraction?
So to find an abuse of discretion and to overrule a trial court, what the Superior Court has to do is find that the decision was manifestly unreasonable, arbitrary and capricious, failed to apply the law, or motivated by bias or ill will. What they can't do is change the law. And what the Superior Court, the majority here did, was they changed the law. And if I might, let me just read one sentence from the Superior Court's decision where the majority didn't follow the law. The majority said the percentage of a company's overall business that it conducts in a given county standing alone is not meaningful and is not determinative of the quantity prong. If I were looking at that in a brief from my colleague, Mr. Muha, I would say, what's the cite for that? And the answer is, there is no cite for that.
Can I follow up on that point right
Certainly,
there?
Your Honor.
And I apologize for interrupting you, but
that's all right.
wouldn't it make a difference in this case if your total sales were $75,000 per year, whether it was one sale of $75,000 product or 10,000 sales of a product that was $7.50? I mean, there's a continuum scale that can slide from the one sale to 10,000 sales. You could have 100 sales at $750, and all that would make a difference on your view of that activity. And that kind of bothers me with this.
I get it, Your Honor. It might, but that, first of all, the defendant's duty is to raise the issue. And under Rule 1028, we raised it, and we established a record. The plaintiff's duty then to go forward is to establish, oh no, there's enough evidence here to countervail that. And they have to do their job too, the plaintiff does. And then the trial judge weighs it. But what we don't allow is we don't allow the Superior Court to then stand in the shoes of the trial judge and say, I disagree with Judge New, the new. They don't get to do that. It's either an abuse of discretion or it's a de novo review. And here, the review is not de novo, although I would argue strenuously that that's exactly what the Superior Court did. Instead, it's abuse of discretion. And under an abuse of discretion standard, you cannot change the law and then say, oh, well, Judge New didn't follow the law that we're now saying is the law. No, that's not how it works. And so it is, I am not advocating, as Justice Weck said, I am not advocating for a bright line test. I am advocating for this body to send a message to the Superior Court that standard of review means something.
Counsel, may I follow up on that?
Yes,
Was
Your
the
Honor.
Superior Court wrong in saying that each case is dependent on the facts and circumstances, the totality of the facts and circumstances?
Yes, Your Honor.
They're wrong about that. They said that.
Who said
The
that?
Superior Court said
They
that
did.
each case is
Right.
dependent on the totality of the facts and circumstances. Is that incorrect?
So I'm not entirely following each case, under Purcell, each case is to be evaluated on its own.
And the Superior Court, I believe, was saying that the trial court did not correctly apply the law because its decision was based exclusively on the percentage of sales without consideration of the other facts and circumstances. Footnote, authorized dealership in the venue.
So
Is that wrong?
my colleague, Mr. Bashman, has said in his brief, and I agree with it, he said, look, opinions of court are not statutes. And Judge New, when he wrote his 7 or 8 page opinion, he didn't include the fact that Husqvarna doesn't have an office there, doesn't have employees, doesn't have all the things that I've already told you about. Don't pay taxes, no address, they don't have a storefront, they don't have a manufacturing facility or a distribution center here. They don't have any of that. He didn't include that, but that was all evidence that he reviewed and that was presented to him when he found that Husqvarna was not regularly conducting business. Now, we know that the scope of review by the Superior Court is plenary, but the standard of review is abuse of discretion. And why am I saying that? Because the Superior Court could look at all of the evidence that I just gave you, that we don't, that Husqvarna does not have a business front, and all of those things. And the Superior Court can then say, did Judge New abuse his discretion? Well, he followed Cantor and Zampana Berry and Monaco. He followed them all. And he didn't, I disagree with Mr. Bashman, where Mr. Bashman in his brief says that there was a 1% bright line test. Never in Judge New's opinion does he say that. Rather, what he does is he shows what the national average would be, and he shows what business Husqvarna was doing in Philadelphia and in Bucks County. In Bucks County, Husqvarna does 40 times more business than they do in Philadelphia County. And so, look, under due process and under equal protection, we want to treat all corporations the same, and the proportional test is fine, and the way Judge New did it, frankly, is very convincing, because he looked at the test as it relates to Husqvarna and said, Husqvarna's 6 times lower in Philadelphia County than what they would sell on average in the United States in general, and they're 40 times lower than what they sell in Bucks County. So they're not regularly doing business here.
Counsel, I'm not sure a comparison of another viable forum is the test for whether Philadelphia is the wrong forum. But if I'm understanding your argument, you acknowledge that Judge New, in his 1925 opinion, only focused on the percentage, which seems to be what the Superior Court had a problem with, correct?
I'm not going to argue with you, Your Honor. I mean,
Well, I just
he
want to make
didn't
sure.
inclu- I mean, I know
want to
that
understand,
he.
because I think your argument, if that's true, which I think it is, I think your point is, and as I think multiple appellate courts have said, when reviewing a trial court decision for abuse of discretion, it's not necessary that the trial court cite every piece of evidence that the trial court relied on to reach a decision.
Precisely.
And that's why, so your argument is what the Superior Court should have done was look at everything. If they were going to say that that Judge New abused his discretion, they had to look at his decision in light of all of the evidence that was produced, not just the evidence he cited in his opinion, and decide whether the result that he reached was an abuse of discretion in light of the evidence.
Certainly, it's the standard of review. The standard of review is abuse of discretion, but the scope of review, the what, is plenary. The Superior Court can look at all of the evidence, but then they have to determine the standard of review, which is an abuse of discretion standard. And my overriding point is you don't get to change the law and then say Judge New abused his discretion.
Okay, we understand your argument. Are there any other questions for Mr. Bodie? All right, thank you, sir. Let's hear from Mr. Bashman, who apparently can't get enough of us.
Chief Justice Todd, and may it please the court. My name is Howard Bashman. In this case, I represent the plaintiffs Ronald and Rosemary Hangey. With me at council table are Robert Mongaluzzi and Aura Avragan. The record shows that Husqvarna's products are continuously offered for sale in Philadelphia County through Husqvarna's authorized dealers, and the evidence shows that the sale of those products to consumers are occurring on a frequent and regularly recurring basis rather than being isolated and limited. The trial court in this case and several other trial courts before it transformed decisions holding that 1% of a company's total business in a given county suffices to conduct regularly conducting business into a necessary minimum amount. These courts took something that was deemed sufficient and made it mandatory, a necessary requirement to qualify as regularly conducting business. That was legal error, which constitutes an abuse of discretion. Indeed, if that were the law, Husqvarna could have $5 million in annual sales in Philadelphia County and still not qualify as regularly conducting business there. This court's decision in Cantor versus American Honda compels affirmance of the en-banc Superior Court here. The relevant facts of Cantor, which led to the reversal of the trial court's order in that case, transferring venue from Philadelphia County, are all but indistinguishable from the relevant facts of this case. Annual sales in Philadelphia County and Cantor range from $35,000 to $40,000 per year on the low side to approximately half as much as this case involved, to $70,000 to $80,000 on the high side, exactly the facts of this case. The automobiles being sold in Cantor were on average way more expensive than the products Husqvarna has been selling in Philadelphia County, as shown by the record here, and we have the reproduced record sites in our brief, and I have them handy right here if you need them.
Can I ask you a question on this? Because I'm searching, as I was with Mr. Bodie, the standard that this court should articulate, if any, in this case. And I take it that you're also not advocating for a bright line rule, or you can correct me if I'm wrong on that. And furthermore, if the test is going to be an abuse of discretion, what meaningful guidance can this court provide that would provide an adequate standard for trial courts beyond saying don't be a wild outlier in this direction or in that direction, because if there's not going to be a number, a fraction, a percentage, I'm just wondering if these cases just don't come in seriatim and the courts just have to say, yeah, we think that's okay and know instinctively we think that one's not okay? Is it just the seat of the pants judgment? How can we come up with any satisfactory standard to deal with these cases?
Well, obviously, this is the case that you're presented with today, and I think that is a very difficult question. You know, I disagree with the other side that they're saying that there's not some cutoff, because they are saying there's a cutoff. They're saying that their number is not good enough. Apparently, something is good enough as a percentage of sales in a given county alone. And the problem is they're not here to tell you what the answer is, which I think is a fatal defect in their argument. You know, I think the best hypothetical to try to compare this case with the real world outside of this case is does Ford Motor Company regularly do business in Philadelphia County? There are 3 Ford dealerships located in Philadelphia County: Pacifico Ford, Chapman Ford, and Dunphy Ford. In 2022, Ford had $108 billion worth of sales in North America. If we take 1% of that, they'd have to have $1 billion worth of sales in Philadelphia County to be regularly doing business in Philadelphia County, even though, similar to Husqvarna, they have dealerships that are open every day, more or less, in Philadelphia County, selling Ford products.
But isn't that the key to your argument? I mean, I'm struggling, because, I mean, if you're suggesting that this percentage of sales is sufficient, then Justice Wecht is right. I mean, we're wasting our time. I mean, that's an abuse of discretion kind of standard, and the trial court was in its discretion to do what it did. If, on the other hand, your argument is a defendant who chooses to have a presence in the forum on a continuous basis establishes the general and habitual nature of the activities in the forum, and that fulfills the quantity test, irregardless of the percentage of sales.
Right, that's absolutely my argument, and I thank you for letting me say that I'm not arguing the other thing. I'm not here to say that percentage of sales should govern. In fact, we're saying absolutely the opposite and precisely what you just summarized, which is that having a presence through an authorized dealer in Philadelphia County is sufficient. And to address what Justice Mundy had asked, it's possible to have 1 or 2 sales of a particularly expensive product and get to 1% of a company's total revenue in theory. And my argument to you is not that would be sufficient. The Superior Court en banc and the panel before it got it absolutely right by saying that percentage of sales is not the sine qua non of deciding regularly doing business.
But in your response to Justice Donahue's question, physical presence, regardless of whether you sell a single product, is dispositive.
No. The fact that the record here shows that there is in the record evidence of what the sales were on an annual basis. And there's also evidence.
That's not my point. And I think Justice Donahue framed it to you like, why are we talking about percentages? You know, you have an authorized dealer here. You availed yourself of the forum. You sold a product. Why are we talking about whether you were successful at selling or not selling? You were there. You were offering your products. And my question to you is, your position would be, I think, that the physical presence of an authorized dealer offering your products for sale, regardless of whether you sell a single one, is dispositive, and the fact that the trial court judge didn't treat it as dispositive was an abuse of discretion.
I think that I disagree with your recharacterization of my argument for the following reason. There's both what's known as the quality and the quantity standards that this court has announced in a series of decisions. And if no sales are going on through the authorized dealer, then I think that you fail to satisfy the quantity prong of the analysis, because there's nothing that's going on in that county that advances the central component of the business that's being sued.
And that's because, counsel, isn't it, that we're dealing here with the prong number 2, regularly conducts business, right? That's why the court's developed the quality, quantity, continuous, and sufficient. Am I right?
Right, and it's undisputed here that the quality prong is satisfied. Husqvarna concedes that. Judge New recognized that. And
But you want a little bit of everything, right? You want the standard to be you look at everything. You look at the quantity, you look at the quality, you look
Precisely.
at the continuous nature, the regularly conducted business, you look at everything.
And if I can just touch on very briefly the abuse of discretion argument that the other side makes. In preparing for this argument, I went back and looked at the cases, and Your Honors have already pointed out, some of the cases they're relying on. The Villanova case, that was a Superior Court decision. But this court's ruling in Monaco, which was the first one to take on this issue, and then 2 years later in Cantor, and then even 13 years later in Purcell, each one of those reversed the trial court's decision on the venue issue. And I believe that Monaco and Cantor were both direct appeals to this court from trial court rulings. And this court applied the abuse of discretion and said the trial court got it wrong as a matter of law. Now I heard Mr. Bodie argue, the Superior Courts can't make a new ruling of law and apply it to the case without constituting an abuse of discretion. This, as Your Honors have all recognized, every one of these cases presents its own facts and circumstances. And it was dealing with this case, and it decided when you had a billion-dollar company, which none of these earlier cases involved, that the percentage of business in a given county perhaps becomes less meaningful than in the earlier cases that had arisen, which were not ones that, especially in front of this court, were not ones that involved such large companies. And so the Superior Court ruled that Judge New committed an error of law, and the abuse of discretion standard has as one of its elements, and Mr. Bodie even said it, did the trial court commit an error of law? And that was the basis of reversal.
So what was the error? What was the error?
The error was in viewing as dispositive the fact that the percentage of sales was so low. And let me just clarify one thing that you had asked earlier, which is we've been in this case together throughout the appellate process. So this is our third appellate oral argument of the case. And the other side has been very consistent in pointing out at each step that here's all the facts that were in front of Judge New. So it's not like the Superior Court didn't know any of the things that Mr. Bodie is saying about there was no physical presence, there's no this, there's that, no that. All of that was there, and the Superior Court understood that and recognized it, and they looked at Judge New's decision and said, the reason that Judge New decided, so none of that's there, so that doesn't weigh in our favor. One thing weighs in our favor, and the question is that enough or not? So it's not an issue of, all these other things overcome the one thing. They don't, and that's what the Superior Court decided.
Counsel, I have one final question for me, and it gets back to this conflation of the quality and quantity tests. I'm not so sure that you're correct in giving up that point here, but tell me if I'm wrong. I mean, let's say that the defendant here had $75,000 worth of sales through Lowe's and Home Depot, that hypothetical. Okay. That would be evident. Sale of their product is the essence of their business, and so that would fill the quality test. But it wouldn't have anything to do with the quantity test. And they would fail the quantity test if that's how they met the quality aspect of this analysis. The difference here is that the way they met the quality analysis was to have a physical presence in the venue by virtue of the authorized dealership. So you can have a situation where you meet the quality but you don't meet the quantity. I'm just wondering, in this situation, can you ever not meet the quantity aspect of it because of the physical presence in the venue, which establishes the habitual and general nature of the activity, which is all this test is about. It's to answer that question.
Right.
Even if they never successfully made a sale.
If the court wishes to conclude that, I think that my side still prevails, and we're happy to have that as the rule.
I'm not sure, but I mean, I see the possibility in this situation. I mean, it's a narrow situation, but I'm not sure how frequently or infrequently it comes up. But I mean, that is a distinction in this case.
And again, since the quality prong was conceded and was accepted by the courts below. That has never been a scenario that this case actually itself presents. But if I'm back arguing that case, I will be happy to have you up there.
Okay, does anyone have any other questions for Mr. Bashman? Thank you.
Thank you,
you
Your Honor.
both. Very well argued. Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania versus Kevin Jackson, representing Mr. Jackson, James Lloyd III, representing Commonwealth, Mr. Brady Mejia.
Oh, I know.
A Philadelphia police officer was in his patrol car when he heard several gunshots. He drove in the direction of the shots and saw the appellant running on the sidewalk towards his car. The officer exited his car and asked the appellant why he was running, and he replied that he was running from the gunshots. The officer directed him to stop, but the appellant kept running, and the officer gave chase. As the appellant ran, he discarded a cell phone and a handgun. Prior to a trial on gun-related charges, the appellant moved to suppress evidence of the gun, arguing that he was unconstitutionally ordered to stop because the officer did not have reasonable suspicion to believe he was involved in criminal activity. The trial court suppressed the evidence, the Superior Court reversed, and we accepted review to assess that determination. Good morning.
Good morning, Chief Justice, and good morning, Justices. It's a pleasure to be here. Thank you. That sounds like what I wrote in my brief to the Superior Court as my statement of facts and what I wrote in my aliquotter almost word for word. Typically, when I'm here before this court arguing from the criminal defense side, I'm trying to break new ground or expand something, or I'm making what is kindly referred to as a very novel argument, Mr. Lloyd. Here I find myself on the other side of the table, so to speak. I'm asking the court to reaffirm what this court has said and the Supreme Court of the United States has said and Superior Court of Pennsylvania has said over and over and over again. And that is, in order to justify a stop or a seizure based on reasonable suspicion, the officer has to have a particularized belief that the person that is being stopped, the particular person that is being seized, is involved in criminal activity. And that, although there was lip service paid to that in the Superior Court, they actually used that exact phrase. That's not what happened. Mr. Brown was not suspected by Officer Swinarski of being involved in criminal activity. He was actually directly asked that question at the hearing and said, no. At the moment I said to him, stop, after I initially said, what are you doing? And he said, I'm running away from the gunshots. He asked Mr. Brown, well, why are you running? He said, I'm running away from gunshots. And then he said, stop. And at that moment is when I think we all agree the seizure occurred. And at that point, defense counsel at the motion asked the officer, well, at that moment, when you said stop, were you stopping him because you believed he was involved in criminal activity? And the answer was no. The Superior Court, I think, reached the wrong decision based on two principles. And one was, when they looked at a prior Superior Court case, Bryant, there was some looser usage of language. Although that was also a reasonable suspicion case, there wasn't that formula we've heard over and over again, that the officers have to have a particularized suspicion that the person stopped was involved in criminal activity. In Bryant, the court said that the defendant who was stopped there was acting in an unusual and suspicious manner. And they didn't finish it out, but the import of their ruling and all the other cases they cited used that full language. And the Superior Court said that this case was analogous with Bryant, and there are certainly some similarities. They both happened in Philadelphia. They're both situations where police heard gunshots and did what they are duty-bound to do and ran toward them. And in this case, we saw only Mr. Brown running from the scene. The officer never made it to the actual scene of the shooting. He was on his way there, and Mr. Brown was running away. Mr. Brown wasn't running from the officer. He was actually running toward the officer when the officer first comes upon him. In Bryant, the officer testified this was a high crime area. Here, the trial court, the suppression court, found that it was not a high crime area, that specifically the Commonwealth hadn't carried its burden. They did not meet the burden of establishing it was high crime. I know in their brief they point out that Officer Swinarski said there had been an increase in gun violence over a period of years in that area. And again, defense counsel...
Why is that important, counsel? Why are you talking about a high crime area?
Because the amicus brief, I think, is kind of misleading.
What does it have to do with your case? I mean, I'm
well,
because we said very recently that that factor is irrelevant. So what are you talking about? Why are you talking about that?
Because the Superior Court relied on Bryant, and that was an essential element in Bryant. So in Bryant, there were three factors: high crime area. The men who ran in Bryant were running when everyone else remained still, and that's what raised the officer's suspicion.
Don't you lose under Wren? I mean, if we look at what an objective perspective would give you of your client running from the scene, it could be the shooter.
But that's not even what this officer believed.
But Wren would say that doesn't matter. If the objective circumstances would leave one to conclude something even other than what the police officer said he thought at the time, it's sufficient to support the suppression.
Well, here the officer was directly asked about Mr. Brown's behavior, and we have to view this through the eyes of that officer, and that's the record that was built here.
Not under Wren, we don't.
The direct testimony was that Mr. Brown's behavior was normal.
I know, but if there is an objective manner in which to perceive that same evidence that would lead to the conclusion that criminal activity may have been afoot, don't we have to look at that?
But it only supports reasonable suspicion, and even applying that, it only supports reasonable suspicion if Mr. Brown's involved in that activity. And he's, from his own words here, it's the opposite of involvement from it. He's running away from it.
Counsel, may I ask, the issue before this court is whether the Superior Court committed an error of law with regard to, it said, was the person seized by police even though the officer did not suspect the individual stopped of criminal activity. Does the fact that both of you agree that the detention occurred at the word stop and the defendant continued running, which flight in and of itself indicates guilty knowledge, how does that take into consideration the issue before this court that the officer did not take into consideration the flight as part of criminal activity?
Well, here it's significant that the flight did not begin upon police arrival. This isn't a classic, I think it's DM is the case, Illinois versus Ward law, where it's unprovoked flight in a high crime area or something along those lines. Here, we know what provoked the flight: running for safety, running away from danger as the police officer was approaching it. Here, the officer and Mr. Brown were moving toward each other. Mr. Brown was not trying to evade the officer. He didn't turn around when the officer pulled down the street in a marked car. He didn't make, you'll see it in the case, the blading motions, trying to hide anything, trying to run away from the officer. He continued in the exact path that he was on and even answered the police officer's question as the police officer said, "Why are you running?" He said, "There's gunshots," which the officer himself had heard at that point and was moving toward.
Forced abandonment was never an issue in this case, was it?
It wasn't, because we agreed that as soon as officer told Mr. Brown to stop after Mr. Brown answered the first question, that itself constituted the seizure. So that brought it within Matos and long line of case law that says as long as it's abandoned after the seizure occurs. This wasn't, which weren't the facts here, and I think we do agree on that point.
So it's your position that the circumstances viewed objectively do not support the stop?
They do not support a particularized belief that Mr. Brown was involved in criminal activity.
Irrespective of what the officer said, the objective facts do not support the stop?
Yes, irrespective of what the officer said, if the standard is the way the standard's been written and the way the Superior Court even set it out at the beginning of its opinion, that there has to be a particularized belief that the very person stopped was involved in the criminal activity. Objectively speaking, if one hears gunshots, the normal response is to run to safety. If one sees a bear, the normal response is to run away from it.
Well,
not
and
run
when a
toward
police
danger.
officer says stop, the normal response is to stop.
But when the police officer says stop, there has to be a constitutional basis for it. So that's why the flight after saying stop sort of puts the cart before the horse or court. Something's in the wrong order there.
Okay, anyone have any other questions? Mr. Lloyd, thank you. Mr. Trevino?
Thank you very much.
Good morning, Your Honors. May it please the Court, Grady Trevino on behalf of the Commonwealth. Your Honors, as this Court is well aware, the Fourth Amendment to the Federal Constitution and Article 1, Section 8 to our state constitution prohibit unreasonable searches and seizures. So the question in this case and in any case in which we're considering whether or not a police officer's stop of a citizen was constitutional or not is whether or not the officer's actions, based on what he knew at the time of the stop, were those actions reasonable. Certainly. Under the facts that were known to the officer at the time that he stopped the defendant, those actions clearly were reasonable. What we have here is an officer on patrol in an area that had seen a large increase in gun violence. The officer hears multiple gunshots. The officer is on his own. He immediately drives toward where the gunshots sounded from. He sees the defendant fleeing from that area.
Wait, just a minute. Let's not say fleeing. He was running.
He was running.
Thank you.
Running from that area. The defendant is the only person who's out at all, the only person whom the officer sees. Before the officer stops the defendant, he asks the defendant, "Why are you running?" The defendant says, "I'm running from the gunshots."
Did the defendant have any obligation at all to answer the police officer? Was there any basis under Terry commanding him? Couldn't he have just kept running?
Well,
Just a person running.
Well, Your Honor, I think there's, as I understand it, two different questions. The question is whether or not an officer can stop the defendant, and I think he was entitled to do so under these facts. And then the question is, is he required to answer the officer's questions? I think the answer to that is no, that an officer can never force somebody to answer questions. You would need to bring a person into court in order to compel the person to answer questions. But the officer is entitled to put himself in a position so that he can ask those questions to the defendant or to the person who stopped and see whether or not that person would want to.
But counsel, outside of the facts, the rule by the panel in this case specifically ruled the police can conduct a Terry stop when they have reasonable suspicion an individual is a perpetrator, victim, or eyewitness of a possible shooting. Share with us where there is case law, whether it's United States Supreme Court or this court, any lower court, that indicates that a witness, an individual eyewitness, it's permissible for a detention of a permissible witness.
Sure, Your Honor. Well, I think there are really two different standards that apply here potentially. Number one is the Terry standard, and I agree that under Terry, you normally have to suspect that the person you're stopping is himself engaged in criminal activity or has engaged in criminal activity. And if I could just very quickly, I disagree with my colleague. The officer in this case repeatedly stated, I thought that he was possibly an offender. He said, I thought he could be a witness. He could be a victim himself, or he could be an offender. So it's our argument that under Terry that that's a sufficient, a fair suspicion that permitted, and then.
But counsel, a reason, we've all learned when we were rookies, you can't shrug your shoulders and walk away, but a reasonable hunch is not sufficient. What you just put on, what your argument is that he didn't have a suspicion, it was a hunch. He may be. The concept of Terry is that I think he committed a crime.
The concept of Terry, Your Honor, is reasonable suspicion that has been defined by this court, by other courts, as being a standard that's considerably less than the preponderance of the evidence standard.
But it has to be criminal activity afoot. It has to be particularized as to that defendant. And in responding to Justice Dougherty, you didn't grapple with the expansion that this Superior Court panel applied to extend it to victims and witnesses, which Terry and Ibarra and Dunaway have never done. SCOTUS has never approved that. And my question for you is, if we affirm here, who can the police not stop? If we affirm here, isn't it the case that the police could stop anybody in any situation if there are gunshots and people are running away?
Well, Your Honor.
And how does that not violate Terry?
Well, my position is that there are basically two frameworks under which we need to consider this case. The first is Terry, which we've been talking about. But the second framework is just a general reasonableness standard that's been applied by this court in the Beeman case from 2004. And if, when Your Honors review my brief, you'll see my entire second section deals with situations where courts have found, various courts from throughout the country, federal and state courts, have found that if a serious crime has just occurred, if a person is seen in the vicinity of the crime right after it's occurred, if it's believed that that person has information that can help the police respond to that serious crime, that the police are justified in temporarily detaining that person to see if that person can provide information. That's a whole second framework under which we need to consider this case, and it's something that I've addressed fully in my brief. As I've said, cases from throughout the country have held that under these particular circumstances, because we need to remember here that the officer in this case isn't simply trying to play detective and solve a past crime. He's not trying to, gain evidence that we can use in some future prosecution. We have a situation on the street, Your Honors, where someone has potentially just been shot, multiple gunshots. The officer needs to know how to respond. Where are these people who have potentially been shot?
But counsel, we're not discussing the protocol or practice of law enforcement's investigation. We're discussing what is the particularized and objective basis for suspecting a particular person has been stopped for criminal activity. That's the issue. See, you're trying to say to us, hey guys, an officer has a right to detain because we need to know witnesses. That's police procedure and investigation. That's not the issue with the Fourth Amendment. The issue here is, what is the articulation of the particularized and objective basis for stopping an individual who is just running down a street in the city at night, which is called for. I did it many a day.
Well, I think this is a little bit different because this is the only person who's running from gunshots that have just been fired. He's running from that direction. But it's the general reasonableness standard that's been applied by this court.
Well, let's flesh that out. When you say there's gunshots, one alleged gunshots, it's the testimony that the officer heard what he believed to be gunshots.
And we also...
Okay, there was no indication of case shellings or anything, no radio call, all the usual things that come in play. A radio call, man in the area, we got that.
But I don't mean to interrupt, but we have better than that. We have a highly trained officer, hears gunshots, he goes in that direction where the gunshots were fired, he sees the defendant running from that specific area, he says to the defendant, why are you running? The defendant says, I'm running from the gunshot.
No, he said, because I heard, he said, quote, because I heard gunshots, unquote. That's from the suppression record.
That's right, Your Honor, but
And the trial court did suppress.
the trial court did suppress,
And the trial court also said it's not a high crime area.
Every area in this city, but one outside of its racist
No, because-
connotation. What area? Now we could talk Center City, the wealthiest district around, and what we've had in the last 3 weeks, we had 3 brutal beatings. So this is a high crime area where we sit. So that's all nonsense. Coming from Philadelphia, as you know, we all do. That's even worse. It's more bias against our population.
Well, I say it because the Commonwealth doesn't hesitate to rely on that.
Oh, absolutely.
And they don't even have that to rely on here. So anyways, the trial court suppressed, I jumped in because the suppression record was because I heard gunshots. I'm sorry, go ahead, sir.
What you're saying is correct. That's what the trial court said, but the trial court was incorrect. The witness, the defendant specifically said, I am running from the gunshots. I point that out in my brief, and
Yes, sir.
the Superior Court.
But let's follow that. I'm running from the gunshots. How is that objectively and particularly significant that he's the shooter?
I think
And let's be honest. The officer's in a marked police car, right?
the officer is in a marked police car.
So I'm a shooter. I'm born and raised in the city. I'm a shooter, and I'm going to run towards the cops. Are you kidding me? I'm going up the next alley.
Well, what happened here, Your Honor, is the officer hears the gunshots. He drives up to the corner. He turns the corner, and then he sees the defendant running in his direction. He asks the defendant, why is he running? Of course, the defendant's not going to say, I'm running because I just shot 4 people. He says, I'm running from the gunshots.
Okay, we have a very factually intense case here, and we're going to take a close look at it. Does anyone have any additional questions?
Yes, I do.
Okay.
Counsel, just as the Chief Justice said, we have a very fact-intensive case. And in this case, the suppression record included the officer testifying, I didn't know if he's injured, he could have been shot, in shock, he could have been a good witness or possibly an offender at that time. How does that allow us to invalidate the suppression court's judgment that that was not a valid Terry stop?
Well, I think that information is sufficient for a valid Terry stop, but let's just pretend that the officer knows for certain that this defendant wasn't the gunman. He would still be entitled under the standard, the reasonableness standard that's been set up by the United States Supreme Court, that's been set up by this court, that's been followed by courts from throughout the country, that's been followed by Professor Lefebvre, who we've all studied from when we were in law school, that if there's a serious crime that's just occurred, if a person is believed to have information that will help the officers respond to that serious crime, that person can be temporarily detained. That's
Okay,
what
we're repeating arguments you've already
Can I
made.
follow up on that? Because I just don't quite, maybe I don't understand. What cases are you relying on? Aren't those cases that deal with suspicionless stops that are not, they are systematic, they are set up in a fashion in which there's no targeting of any one individual, but many individuals are interrogated under the circumstances?
Well, some of those cases are that. There are roadblocks.
They all are, aren't they?
No, they're not, Your Honor. Many of the cases that I cite that I discuss at length are cases exactly like this. I cite a case from the District of Columbia Court of Appeals, almost exactly like that. Gunshots are fired. The officers go to where the gunshots are fired. They see people there. They stop the people. They don't know if the person was the perpetrator or a victim or a witness. And the court has specifically held that the fact that the person was a witness to a potentially violent crime that just occurred, that the police are entitled under the reasonableness standard to stop that person for a brief detention. I cite the cases from Oregon, a domestic violence case where the police receive a 911 call. They go to the home where the call has been placed from. A man and woman come to the door. The woman has bruising above her eye. And the officers take the man into custody, and they say to the woman, come out of the house, stay right there, we want to talk to you. The court finds that she's been seized. There's no suspicion that she's done anything improper. But the courts have held that in those situations when we're responding to a serious crime that has just occurred, the police are entitled to briefly detain somebody to find information. And again, this is a situation, we have multiple gunshots being fired on a Philadelphia street. We have an officer.
We know, we've heard it all, so does anyone have any other questions? Okay.
Necessary under the touchstone of the Fourth Amendment, the reasonableness standard, is it necessary that the police officer, before he stops an individual, rule out their innocence or prove their culpability?
Not at all, Your Honors, not at all.
Is there case law from the United States Supreme Court that supports that?
There's plenty of case law that says that case
So
law from this own court. And if you think of Terry versus Ohio itself.
So in this case, the person running could have been a victim or a witness or the shooter? Was it necessary for the police officer to discern that and tease that factual question out before he asked the person to stop?
No, Your Honor, it wasn't necessary. That's why we have the Terry standard, so that the officer can investigate to try to find out what happened.
If you take the argument of some of my colleagues that's been presented here today, would it have been reasonable for the police officer just to do nothing when he's the only person on the street where he heard active shots?
That's the proverbial shrugging of the shoulders. I mean, the officer here did exactly what we as a society want an officer to do. He ran, he drove to the sound of the gunfire.
He was driving toward the danger.
Exactly, and he attempted to find out what happened. Are there people down who need immediate medical attention? Is there a gunman who is still on the loose? This happened right near the elevated train.
Presumably, as an experienced police officer, he knows what a gunshot sounds like.
He does.
And in fact, wouldn't the fact that you heard active gunshots kind of trump the issue of whether or not this was I can't think of the phrase, dangerous area, high crime area? I mean, you knew there was a crime that was committed.
Right. That's why high crime area is sometimes relevant, because it can tell us whether or not these actions are related to criminal activity.
Let's follow that logic. If it's a high crime area and this officer is experienced and believes that a high crime just occurred, more likely than not, that seasoned police officer would be looking for the individual that is the recipient of those bullets, not someone who's running away saying, I'm running from the bullets, because they're in a safe predicament. Considering that there was no one else on the street as per the officer, the only evidence that this court can assume is that this is the only person running, which is consistent with running from gunshots. I guess it's very fact specific, but what is the evidence that this is a high crime area or that a crime even occurred because gunshots? Maybe somebody just had a baby and they were celebrating, as often happens in the city, by firing.
Is that how they celebrate?
Yep, I had a bullet through my car window as a result of that.
And Your Honor, I would
try not to have a baby in Philadelphia.
I would think, though, Your Honor, that discharging a firearm repeatedly on a Philadelphia street is a crime, regardless of whether you actually...
Sorry?
I would think that discharging a firearm repeatedly on a Philadelphia street is a crime, regardless of whether or not you actually hit someone.
Assuming it was a gunshot, other than the evidence of the officer's comments, I believe it to be, with no other further evidence. So the record speaks for itself.
And you would agree with the officer's testimony at the suppression hearing that running from gunshots, from the sound of gunshots, is, as he said, quote, absolutely normal behavior, unquote?
I do agree with that, but I also agree that, I would also point out that this individual was the only person in the area, which greatly enhanced the probability that he was involved in the shooting that just occurred. It's
All
not
right.
like...
We get it. We get it. Thank you so much. Good arguments. Thank you. All right. Would you call the next case, Mr. Minner?
Investors, LLC versus Tufano, M.E.L, representing the Commonwealth control needs, representing needs, investors, Christopher Sullivan.
Well, it's always good to end the morning with a securities case, right? In this discretionary appeal, the issue is presented of whether the Securities Act of Pennsylvania of 1972 requires a plaintiff to plead and prove scienter in connection with an alleged violation of Section 401, which regulates the purchase and sale of securities in the Commonwealth. Also at issue is whether the plaintiff sufficiently pled its claim in the amended complaint. Please proceed.
Good morning, still. Madam Chief Justice Todd and the rest of the justices of our Supreme Court, along with Mr. George Farrell, my colleague. I am Joel Eads. I represent 4 gentlemen, Mr. Dave Crocker, Mr. Dennis Cronin, Mr. Neil Matheson, and Mr. Paul Tufano, all of whom have been for 7 or approaching 8 years now, the unfortunate defendants in a securities fraud case. The court certified a single issue, whether 401 of the Pennsylvania Securities Act requires a plaintiff to plead and prove scienter by clear and convincing evidence. And if so, did the plaintiff, a family-run, single-purpose investment vehicle, sufficiently plead fraud in its amended complaint filed at the close of discovery, which we'll get back to, but I think is an important book note. Not bearing the headline, burying the leads, the answer is yes, scienter is required, and it is actual knowledge that is required. That is undisputed Supreme Court evidence. The answer to whether or not they have pled the complaint with particularity is no. They haven't even come close, and we're going to cite authority from this court that establishes that they haven't told you who said what, when they said it, and what they knew when they said it. All of the precursors to security fraud. Let's start with the statute itself. The Statutory Construction Act admonishes us to look at the language. Language matters. Here, tucked in Part 4 is 401, and that part is entitled Fraudulent and Prohibited Transactions. Where I'm from, fraud is fraud. The Statutory Construction Act of 1924 tells us that while the heading is not dispositive, it is relevant to this court's consideration. I pivot then to the Construction Act 1921B, which says we enforce the language of the statute as written. That statute provides it is unlawful in connection with the offer, sale, or purchase of a security to employ any device, scheme, or artifice to defraud, to make untrue statements, and to engage in any act that would operate as a fraud or a deceit on any person. The language from the 1930s might not sound to our ears like the current status of how we allege fraud, but nonetheless, fraud, devices, schemes, artifices, untrue statements, which reflect the speaker's knowledge. And the catch-all phrase, which proscribes transactions that operate as a fraud or deceit, they mean fraud. And fraud requires scienter, and scienter requires actual knowledge in these cases. Reviewing identical language, except for an Oxford comma. We can talk about that if that is determined to be relevant. Reviewing identical language, the United States Supreme Court in Ernst versus Hochfelder in 1976 looked at this section, and it said that the verbiage is the commonly understood terminology of intentional wrongdoing, and it held that 10b, which is the language upon which 401 draws, requires scienter. The Securities and Exchange Commission invited the United States Supreme Court to parse the 10b statute, subsections A, B, and C. The Supreme Court declined to do so. The Supreme Court noted that the scienter requirement, that the rulemaking authority that the SEC employed was to create a statute that addressed intentional conduct, attempting to create intentional harm.
Counsel?
Yes, ma'am.
Are we looking at Section 401, sales and purchases, and in particular subsection B?
So the plaintiffs have hung their hat on 401B in an effort to say the language there is not as clear as 401A, certainly not as clear as the title fraudulent. But the statute was drawn from Section 101 of the Uniform Securities Act in 1956, which in its official comment drew from SEC Rule 10b-5.
But don't we have to look at the language in the Pennsylvania statute?
Of course,
Section 401, subsection B?
of course we do.
And there's nothing in subsection B that has a scienter requirement, is there?
Well, two things. One, to make an untrue statement, I think reflects upon the speaker's intent. If I'm saying something untrue, I know it's untrue. It doesn't say an erroneous.
That's not necessarily true. I mean, that's not accurate. I mean, you could make a statement that turns out to be not true, but you didn't know it was untrue when you were making it.
And I think the answer is that the U.S. Supreme Court, in looking at identical language, was invited to parse this, and it said no. 10b-5 and its subsections are the creation of the SEC rulemaking authority to prescribe intentional conduct.
But how does that get us around the language of our statute? Isn't that the first thing we do? We look to the language of our statute. If there's no ambiguity, end of discussion, end of analysis.
Yes. But then this court would find itself in the unique situation of taking identical language applied by your United States Supreme Court and every circuit court of appeal and every U.S. district court and applying it differently.
Could I pursue that for a moment?
Yes, sir.
Because in Aaron in 1980, SCOTUS looked at the 33 Act, Section 17A, with the same language as our statute, speaking of plain language, and held that the two subsections do not require scienter. So why would the same plain language analysis not apply? I mean, aren't you just putting the bunny in the hat saying that federal statute applies rather than the 33 Act with this identical language to our statute?
Yeah. And this is quite a rabbit hole that we can go down, but it goes like this. The 1933 Act, unsurprisingly, was written before the 1934 Act. What the Pennsylvania the General Assembly adopted was the Uniform Securities Act, Section 101. The official comment to the Uniform Securities Act says, we have adopted 10b-5 as the SEC interpreted under its rulemaking authority under the 34 Act. Now, it is a mystery to me why the drafters of the 34 Act, because there are some differences, why the drafters of the 34 Act grabbed the language from 17A, put it into, used this rulemaking authority to create a rule that requires scienter, uniformly agreed, and yet allow under the 33 Act a different interpretation under two subparts. There may be some answer in the fact that the 33 Act regulates IPOs, the offer of initial securities to the marketplace, whereas 34 regulates the exchange place itself, offers and sales. It may be that the 33 Act, 17A, does not provide for a private right of action. If you look at all of the cases cited by the department at page 10 of their brief, they're all versus SEC or SEC versus an independent citizen. There is no private right of action. What happens then is that we have one statute that has language similar to both statutes, but the federal statutes have been organized, no private right of action, private right of action. We adopted the private right of action verbatim. We did not adopt 17A verbatim.
Where the private right of action thing is really my jumping off point. Are you familiar with Section 501?
Of the Pennsylvania Securities Act?
Pennsylvania Securities Act.
Yes, sir.
Why didn't you cite it? Because that's, to me, that's the provision that creates the private right of action under Pennsylvania law for a Section 401 violation. And it's specifically, at least as I can tell, addresses your issue here. But it puts the burden on you to prove that it was not a knowing, untrue statement. I mean, it creates it creates civil liability for the violation of 401. So you have to go to it if you're going to bring a 401 section. And it provides that basically, in light of the circumstances, that the purchaser not knowing of the truth or omission and who does not sustain the burden of proof that he did not know and in the exercise of reasonable care could not have known the untruth or omission. That's your burden to prove that. So why are we talking about what they had to do with regard to scienter when it seems like 501 says you file an affirmative defense of it not being knowing or not recklessly made?
So, because I'm a defendant, and I am defending against claims. Claims initially pled as fraud. Securities fraud, common law fraud. We did 3 years of discovery. They can't get close to fraud versus my guys. So what they do? They sought leave to amend their complaint. The trial court gave them leave, and they now seized not on 401, which is the only statute I was sued under. They seized on 401B, and they're trying to dance on the head of a pin and tell you that 401B, notwithstanding it's in subpart 4, fraudulent and prohibited transactions, does not require scienter.
But it says fraudulent and since you want to rest on the title, the fact that it's fraudulent and prohibited practices would suggest, to the extent the titles matter at all, that there are fraudulent practices, and then there are other prohibited practices that might not necessarily rise to fraud. When you combine that fact with the fact that 401B does not have the word fraud in it, doesn't that argue the other way?
Well, I took fraudulent and prohibited transactions as adjectives modifying transactions. That every transaction fraudulent, every transaction prohibited. And then I look at the statute, and 401C is the catch-all. And 401C, the catch-all, says to engage in any act, practice, or course of business which operates or would operate as a fraud or deceit upon any person. And there's a body of federal case law, which is well developed, that is an effect statute, but it is to act as a catch-all. We all know that in 29, the stock market crashed. The 33 and 34 acts were in response to the mayhem that ensued to bring control and engender confidence in our securities markets. The statutes, therefore, were written broad because, go figure, there was no end to the schemes, artifices, devices that were being employed to defraud Americans in connection with the sale or purchase of a security. So while there's very scant legislative history about Section 10, we know that it was to prescribe fraud, and we know that the statute was in response to the never-ending schemes that existed and had created or had reduced confidence in the securities marketplace. So the short answer is A, B, and C are trying to capture everything that can possibly happen in this world to prevent fraud in the sale or purchase of a security.
Counsel, back to my original question. In conjunction with Justice Brobson's point, if we look at the statute, it would appear that in answer to the question that we accepted for review, there's no pleading of scienter required under 401B. However, you can defend pursuant to another provision of the statute by asserting that you didn't know nor could you have known. So why doesn't that just resolve the entirety of the manner in which this type of securities action has to proceed? Without looking to the Act of 33, the Act of 34, we just do what our Statutory Construction Act says and look at the words of the statute.
The answer is because the plaintiffs sued us for securities fraud. They didn't initially tell us A, B, or C. It was just securities fraud. When they couldn't get there, they created a creative argument, because no one has advanced this argument in the Commonwealth before, that they're only trying to sue us for material misrepresentation. The question, I think, respectfully, puts the cart a little bit before the horse, which is, I have law from the United States Supreme Court saying you can't parse this statute. It proscribes fraud, whether it's A, B, or C.
But where does our statute do that? I mean, I'm sort of at a loss why it's wrong for the plaintiff to come forward to say, I'm bringing my cause of action under 401B.
Because, Your Honor, we adopted the 56 Uniform Securities Act. That is accepted. 56 Securities Act, Section 101, says it adopted the language of 10b-5. There's a dissonance. I understand where you're going, because the 33 Act, Section 17, you have attorneys, the SEC, who have interpreted B to apply to negligence. But we've made a policy decision over the course of 90 years that when it comes to a private right of action, whether A, B, or C, it's proscribing intentional conduct.
Well, I'm not sure I disagree with you on that. Where I'm struggling with is your demand, and again, it seems that there are some court decisions in favor of you if we go down this rabbit hole of the 33 and 34 Act and 10b, whatever. Your command that because you can't be held liable for mere negligent untruths, they have to plead an affirmative knowing untruth, when it seems you can read 401 and 501 in harmony to say all they have to plead is an untrue statement under 401, but in order for them to get a cause, you actually should have sued under 501, not 401, but in order for you to prevail on your 501 claim, to have civil liability against the person who violated 401, you, meaning the defendant, have the opportunity to prove that it wasn't fraud, that it wasn't knowing, that it wasn't reckless. And that's, I mean, the statute says it's your burden of proof. So I go back to my question, which you did a really good job at dodging. How do you apply, when does 501A come into play?
So that's not the question that the court certified, and I have not.
Well, sure it is, because we asked what the question is. What has to be pleaded, what they have to plead. But if the burden of proof is on you, then that sort of answers the question. They don't have the burden of proving. I mean, it's possible that a defendant could not raise an affirmative defense available to you under 501A, and they win. But all they have to plead is a violation of 401. And if I'm reading these two statutes, well, it's the same statute, the two sections together, that answers the question that we took, which is to plead a cause of action under 401, you do not have to plead fraud. But to prevail, the court has to consider the defendant's affirmative defense of it not being knowing, untruth, or omission, or reckless. Why isn't that the proper construction of both sections together?
Maybe ultimately it is, but over 40 years of unbroken law applying the Pennsylvania Securities Act, scienter has been required. When you look at the history of the statute, where it comes from, the Supreme Court, scienter is required. It became such a problem, class action securities litigation, that Congress, adopting, assuming, working within the rubric that 10b requires scienter under every statutory provision, doubled down, and it passed the Private Securities Litigation Reform Act in 1995. What did that do? Well, it tried to address the ills that were the securities class action. Relevant here is that it took the fraud pleading requirement, Rule 8 in the federal courts, and heightened it. And it required that the inference of fraud be at least as strong as the inference of innocence, or whatever it looks like that is not fraud in those cases. So when I'm sued under 401A, or 401, and I'm defending a client, and the landscape as I know it is scienter, and I defend the case for 3 years under that landscape and against that burden of proof, and then they seek leave to amend and ask this court to do something that no Pennsylvania court has done, which is remove their heavy burden, which is not only, by the way, an evidentiary burden, but will be a burden at trial, clear and convincing evidence instead of just the negligence standard or preponderance of the evidence. They threw a curveball that is not recognized by any court, that changes the landscape for the defense, changes the notion of what is securities fraud to the practitioner in this state, and we sought interlocutory appeal. The Superior Court gave it to us. They didn't answer the question, so we came to this court. Maybe it works out that it becomes my affirmative defense, and this court will choose to be at odds with all federal courts applying 10b-5. But I think, and I hope, and my gentlemen hope, that more likely it's a fraud statute. Fraud means fraud. They have to prove they intended to defraud these people. You look at their complaint, we all know they don't even get close.
Why not just get, counsel, fraud means fraud, so why not just get the General Assembly to simply throw the word fraud into B and we're done? I mean, if it's so clear, why can't you just tell the legislature, look, you folks have messed up, you need the word fraud in there, and you know, why wouldn't that be the solution here?
So great question. There is law from this court that the General Assembly is presumed to understand how the courts are interpreting its statutes. There have been over 40 years of federal courts looking at the Pennsylvania Securities Act, unanimously requiring
Federal courts.
Yes, sir, but that's only because our state courts have not taken it up. I don't know why that is.
Counsel, the presumption is that the General Assembly knows how this court is interpreting a statute. This is a case of first impression, correct?
This is a case of first
impression. We don't have any
impression.
presumption at all about what the General Assembly thinks this court has done.
Well, the authority that I cited in my reply brief, I understood to apply to the appellate courts of the Commonwealth. But I think if the court is done with those questions, we can pivot to the amended complaint if you care to take a look at it. Okay. So in conclusion, 401 requires scienter under every subsection. They haven't come close to pleading it. This is their attempt in an amended complaint at the close of fact discovery that was lengthy and expensive and time consuming. They still didn't get there. In fact, they changed very little of their fact in support of their claims. For these reasons, the complaint should be dismissed with prejudice. They've had their shot. The litigation is over. Thank you very much for hearing me.
Thank you, Mr. Eads. Mr. Lavelle?
Good morning, Madam Chief Justice and Justices of this Honorable Court. My name is Christopher Level, and I'm here on behalf of M.E.L Investors, LLC, the Aplt.
Regrettably, we have now passed into the afternoon.
Well, I'll amend. Good afternoon. I'm here with my co-counsel, Jeffrey Kurtzman. M.E.L Investors, LLC respectfully asks that this court affirm the Superior Court's decision and conclude that, as written, Section 401B of the Pennsylvania Securities Act does not require a party to plead and prove scienter. Appellants urge this court to adopt an interpretation of the statute as they wish it were written. The statute is not, however, written in a way that supports this interpretation. The plain language of the statute simply does not contain language that would bear the imposition of scienter. Now, this court's been given two competing narratives about what the true antecedent of Section 401B is. On one hand, we have the appellants who argue that the proper antecedent of the PSA is the SEC Rule 10b-5, which is derived, of course, from the 1934 Act, which is in turn derived from Section 10B of that, and the line of federal cases that come from Ernst & Ernst versus Hochfelter, and that should control the outcome.
What about the section of the Pennsylvania statute where the General Assembly has clarified that this act shall be so construed as to effectuate its general purpose to make uniform the law of those states which enact the Uniform Securities Act, and to coordinate the interpretation and administration of this act with related federal regulation? That's at 70 PS, section 1-7.
Thank you. Yeah, well, two comments in response to that. First, there are differing holdings from the Supreme Court about what the federal securities laws require. As was referenced earlier, under the 33 Act, Section 17, there is not a requirement of scienter, where in the 34 Act, 10b-5 rule, there is. Now, other courts in this country have faced this issue. The Supreme Court of Washington has dealt with this precise issue. And looking at the language that you just stated about coordinating with federal policy, they concluded that coordination doesn't mean precise imitation. It doesn't mean you have to exactly copy what the federal statutes do. It would obviate the reason for states having their own blue sky laws, such as Pennsylvania has. And I would submit that so long as Pennsylvania's rule isn't interfering with or hindering the application of the SEC and the federal securities laws, it can coexist alongside it, and it has for a number of years. On the other hand, we have the Department of Banking and Securities that has filed an amicus brief here, and they've urged this court to recognize that the true analog of this statute is Section 17A of the 1933 Act and the line of cases that we talked about in Aaron versus the SEC, and that should control the outcome. Now, our position is that although we agree with the interpretation submitted by the amicus on the point that the statute before this court today does not require pleading and proving intent, we don't think the court needs to go there. We don't think the court needs to make a finding on the law's true, proper federal analog to resolve this dispute, because I think the court can look at the plain language of Pennsylvania's own statute and understand what it means.
Do you agree with the department?
We agree with the department to the extent that, in terms of what the true analog is, I think there's evidence going both ways, and I don't think, again, that it's highly pertinent to the outcome here. We do agree with them that the statute 401B does not require to plead and prove scienter.
And would negligence be enough, or is it a strict liability provision? What does B mean, or what does B require?
Our position is that it is essentially a strict liability claim that is, of course, subject to defenses that are set forth in Section 501 of the PSA.
Which would take it away from strict liability.
Yes.
So it really is a fraud statute if it is a fraud statute, but the fraud is sort of presumed unless the defense proves meets its burden of proof that it was not knowing untruth or omission, did not know in the exercise of reasonable care that it was untrue. So it really is a fraud statute, but it's up to the defendant to prove that it was not a knowing or reckless untruth.
Your Honor, I think that it's certainly subject to those defenses. We wouldn't agree that it is a fraud statute. I mean, if you look at Part 4 of the Pennsylvania Securities Act, it's referred to as fraudulent and prohibited practices.
No, I know. I'm focusing on the cause of action, which you wouldn't have but for the existence of 501, because 501 gives you the private right of action. There's plenty of other statutes give criminal penalties. This has a criminal penalty provision. It gives enforcement provisions to the agency. This does that. Generally, when that happens, if you were supposed to be recognized a private right of action, the General Assembly has to authorize it, which they did on 501, and by recognizing that defense, would seem to have expressed the General Assembly's intent that defendants should only be held liable if they fail to prove by a preponderance of the evidence that their statement was unknowing and not reckless.
I would agree. I would agree that there is a burden that the defendants can take up to show that it was effectively an innocent misrepresentation, even though it was in fact untrue at the time. I mean, I construe the statute that our burden is to show that this was the sale of a security, that there was a misstatement that was made, that was untrue when it was made, and that it was material, that it was important to the transaction of the security. I do want to address comments that my esteemed adversary made concerning the reason for why we amended our complaint, just by way of a historical footnote. I mean, it's set forth in our motion to the Bucks County Court of Common Pleas to amend, and that is one of the main reasons why we did it was not because we didn't have the facts. We have many facts, in which we previewed in that motion about things that we would expect to put on at trial. The reason why we did it was to take the words fraud out of the complaint with an aim towards possibly fostering a settlement. I mean, we stated this in the motion. So it was hardly a moment of waving the white flag and saying, gee, we don't have enough evidence. There was a reason for it.
It doesn't matter if it was made within the statute of limitations, and that has not been an issue in this case. So it doesn't really matter why you amended. Am I right?
Correct, Your Honor. So with respect to the comments concerning whether or not it's adequately pled, we would ask this court to agree with what the Superior Court wrote, which is, even if a court were to decide that scienter is a requirement under the statute, it's adequately pleaded here. There is specificity. There are dates. There are assertions of fact. There are a setting. There's a time and a place. There's speakers. Even if one of the four isn't identified, it's not as if we said someone. It's one of the four defendants that are before this court today. So we think that it's adequately set forth in our amended complaint, and we ask the court to affirm the Superior Court's decision.
Thank you. Does anybody have any questions? You know, it's a shame that we're not offering CLE credit in securities law for this argument, because it's been outstanding on both sides, and thank you very much.
Thank you.
Mr. Minner?
I don't know. That's right. That's right. Yeah, that's right. Exactly. That's exactly right.
Okay.